ADA Travers. So other than that, all the other parties are present. So petitioner, may you call your next witness, please?
May I be heard on the scheduling issue, please?
Sure.
Thank you. I just wanted to bring this, good morning, presiding officer, Campus John McDonald for the petitioner. Just wanted to give you the latest update on our witness list. As you know, today we have Trooper Ryan Seaver from the Massachusetts State Police is going to testify. On Wednesday, April 20th, we have Clerk Brendan Keenan scheduled to testify, but because of an irreconcilable conflict with Judge Despotopoulos' attorney, his attorney cannot be here, so we cannot call Judge Despotopoulos on Wednesday the 20th. So on Wednesday the 20th, we would expect Clerk Brendan Keenan to testify in the morning, and then pursuant to the agreement with Attorney Bourgeois, we believe that he would call Mr. Travers to testify.
Okay.
So those would be the two witnesses on Wednesday the 20th. And then I spoke with Attorney Sullivan, and we've confirmed, as of that conversation, Judge Despotopoulos for Thursday morning, which would be the 21st.
Okay. Let me just ask the respondents, do you have anything you want to say? Let me also, yeah.
Preliminaries, no, I don't, Your Honor.
Let me raise this point, and whatever you folks decide is fine with me, candidly. So, Wednesday will be, somewhat busy with those two witnesses, I think. And then on Thursday, I take it that judge will probably testify about as long as the judge yesterday testified.
That's probably a yes.
So, a couple of hours. So, I'll leave it to the respondents. Do you want to wait until, when do you want to start putting your case in? As I said, I'm more than happy to take witnesses out of order, but that's your decision, frankly. So you want to call a witness potentially on the 20th, you want to call a witness on the 21st when there'll certainly be time, or do you want to not put your case on until the petitioner rests and then you can decide what you want to do?
We're gonna have to consult, and we'll have to involve, well, we may not have to involve Mr. Bourgeois in that. But we'll let Ms. Duca know as soon as we know, and we'll certainly let the petitioner know as soon as we know.
Yeah, and once again, I would appreciate you sharing with the petitioner what witnesses you want to call, when you want to call them, and so, yeah, very good. Okay, if there's no, thank you.
Thank you very much.
Thank you. If there's nothing else, thank you, Ms. Brown.
Your Honor, the petitioner would like to call witness.
It's inside. You can see it. You ready to call your witness?
I am, Your Honor. The petitioner calls Ryan Seaver to the stand.
Okay. Yeah, hi, yeah, Trooper.
Good morning, sir.
Good morning to you.
Pardon
It
me,
was-
here it is, right here,
Oh,
in the front.
oh, someone
Yes.
put the link in. I need it.
I put it
Hi,
there.
could you raise your right hand, please? Do you swear to tell the truth, the whole truth, so help you God?
Yes, sir, I do.
Okay, thank you. Please be seated. Do you want some water?
Please, I'll take a second one, thank you.
Good morning.
Good morning, ma'am.
Would you please state and spell your name for the record?
Trooper Ryan, R-Y-A-N, Sevier, S-C-E-V-I-O-U-R.
Thank you. Mr. Seaver, are you appearing here today because you received a subpoena?
Yes,
Are you represented by an attorney?
yes.
Who's your attorney?
Attorney Leonard Keston.
And you just pointed, is your attorney here with you today?
Yes, he is.
Thank you. Trooper Seaver, please describe your education after high school.
I have a bachelor's degree from the University of Massachusetts at Amherst in legal studies, a minor in sociology, and a certificate in criminal justice.
When did you graduate from UMass?
2011.
Are you currently employed?
Yes, I am.
How?
I'm a state trooper with the Massachusetts State Police.
And when did you start that job?
October of 2015.
Prior to October of 2015, had you held any other law enforcement positions?
Yes.
Could you please describe those positions?
2011, I attended the Plymouth Full-Time Police Academy, sponsored by the Worcester Police Department. After successful completion of that police academy, I was a full-time patrolman for the Worcester Police Department until 2013. In 2013, I left Worcester and went to the Canton Police Department as a full-time patrolman there from 2013 until 2015 when I entered the State Police Academy.
And in 2011, and you're speaking a little fast, so I
Sorry.
can't write as fast. You said you went to the Plymouth Academy in 2011?
Yes,
Okay. And at that academy, did you receive any training regarding report writing?
yes.
And do you recall, who did you receive the training from?
I don't remember the instructor's name from 2011.
Okay. And then I think you said that you went to the State Trooper Academy, is that correct?
Yes,
And can you tell the court are you familiar with RTT?
I am.
What does that mean?
It's the Recruit Training Troop. It's the acronym that follows the number that correlates with which training course you went through to become a state trooper at the New Braintree Academy,
Okay. And which RTT were you in?
the 82nd.
And do you know, in years, what year was that?
It began in 2015 and concluded in April of 2016.
How long is that training?
Roughly 6 months.
Did you complete the training?
Yes,
And during that training, did you receive any instruction about report writing?
yes.
And do you recall, who did you receive the instruction from?
Trooper Jamie McKeon.
And can you just tell the commission briefly, what were you taught about report writing?
In the training, we're instructed to include all relevant facts from our perspective that we viewed and observed during the course of our duty.
Were you given any training regarding the statements of an arrestee?
Yes,
And what training was that?
it should be included and incorporated into the arrest report if appropriate.
And did you receive any training as to when they would be appropriate?
Yes,
And what was that training?
if they were relevant to what had occurred.
I'd like to turn your attention to October of 2017. What barracks were you assigned to?
The C6 Holden Barracks.
And in October of 2017, what town did you live in?
Marshfield, Massachusetts.
In October of 2017, did you work a particular shift?
Yes,
What did you work?
worked the evening 3 p.m. to 11 p.m. shift.
Do you recall, were you working on October 16th, 2017?
Yes, I was.
Legal Advisor Duca, I'd ask that you show the witness what's been marked as stipulated exhibit number 1. I'd represent that that's the arrest report.
Thank you, sir.
Trooper Sevier, do you recognize that document?
Yes, I do.
What do you recognize it as?
This is the booking sheet and arrest report that I completed.
Do you know when you completed it?
The evening of October 16th, 2017.
Is there a time on that report that would tell you when you finished the report?
There should have been an electronic timestamp when it was submitted. I'm not sure what exact time that was.
Let me back up. According to the document you're holding in your hand, does it tell you what time the arrest occurred?
It does.
What time was that?
Just after 7:30 p.m.
And do you know, after the arrest was made at 7:30 p.m., where did you go after the arrest?
From the crash scene to the Holden Barracks.
Do you know what time did you get back to the Holden Barracks?
I don't, but I transported a female, so there should have been an electronic timestamp as well.
Where does that electronic timestamp live?
It should have been on the turret tapes from the 800 series radio.
Can you just explain to the commission what, you're saying turret tape?
My understanding is when you utilize a radio system, there is a recording of that that's maintained somewhere. And when you transport someone of the opposite sex or gender, you start with your cruiser mileage as well as the starting time, and then end with an ending time and ending mileage that should correlate with the distance and time traveled.
And that's particular to when you're transporting someone of the opposite gender.
Yes,
And do you know why that is, that you must make that report if you're transporting someone of the opposite gender?
I believe it's to prevent any sort of view of impropriety or potential issues.
Once you returned to the barracks, what actions did you take?
Again, the booking process.
Is there anything in stipulated exhibit 1 that indicates what time the booking process started?
Don't have the exact start time of the booking process, but for the breathalyzer, there's a 15-minute observation period, and I referenced the start time of the observation for the breathalyzer, so that should roughly coordinate with the booking procedures.
And what was that start time of the breathalyzer?
Began at 20:25 hours, or 8:25 p.m.
I'm sorry, I spoke over you.
No, not a problem. 8:25 p.m.
How long does the booking process take?
Roughly an hour.
Do you know in this particular case how long the booking process took?
I do not.
After the booking process, did you take any action?
I did.
What did you do?
After booking, we'd proceed with the bail process to see if the defendant was eligible for bail and try to facilitate their release.
What actions did you take relative to the bail process?
I would have spoken to the bail commissioner to establish a bail if eligible
And how do you reach the bail commissioner?
by telephone.
And you recall, did you reach the bail commissioner by telephone that,
I did.
do you know when you called the bail commissioner?
I don't.
Do you know how long you spoke with the bail commissioner?
It would have been briefly. I don't know offhand.
What did you do next?
We would let the defendant know their bail costs and give them the opportunity to make a phone call to facilitate their release.
Okay. Do you know, the person who was arrested in stipulated exhibit 1, do you know if that person made a phone call?
She did.
Is there anything in stipulated exhibit 1 that would indicate what time that phone call was made?
I don't believe so.
Did you take any action after that?
In regards to her release,
Yes.
I met with the bail commissioner when she arrived on scene.
Do you know when the bail commissioner arrived?
I don't.
Is there anything in stipulated exhibit 1 that would tell you what time the bail commissioner arrived?
Not that I'm aware of.
Okay. How long did you meet with the bail commissioner?
Very briefly. It's generally only a few minutes.
Did you take any action after meeting with the bail commissioner in regards to the arrestee's release?
Yes.
What did you do?
The bail commissioner was upset with the amount she had placed on the defendant and stated that I should have advised her who the defendant was, and she lowered the bail.
And as a result of that, did you take any action?
Yes.
What did you do?
I returned the currency to the defendant's property, actually to the father, I believe it was, and facilitated her release.
Do you know what time she was released?
I don't.
Is there anything in stipulated exhibit 1 that would say what time she was released?
Not that I'm aware of.
Now, you stated that stipulated exhibit 1 is the booking sheet and the arrest report, correct?
Yes,
Did you write the arrest report?
I did.
Do you know what time you started writing the arrest report?
I do not.
Is there anything in stipulated exhibit 1 that would tell you what time you started?
Not that I'm aware of.
How long did it take you to write the arrest report?
Generally roughly an hour. I don't know for the specific report.
Okay. When you write the arrest report, do you write it longhand or do you use a computer?
Typewritten on a computer.
Do you, how do you enter it into the computer? Can you explain that to us?
With the records management system, RAMs, for the state police.
Is, describe, like, are there boxes that you fill in? Is it a blank document?
There are. So there's boxes that you fill in during the booking process that are transcribed into the arrest reports, and that's what fill in the biographical information and the charges on the cover sheet seen on the front. The narrative itself is an empty box that gets transcribed and copied to the complaint application, as well as the narrative for this packet here.
Let me just back up. If we look at the second page of the arrest report, almost in the middle, but a little closer to the top, on the left-hand side, it says arrest narrative.
Yes,
And below it, there are numbered paragraphs. Do you see those?
yes,
And did you write those numbered paragraphs?
I did.
And do you know how long it took you to write those numbered paragraphs?
A rough estimate of an hour.
And I turn your attention to paragraph number 9. Do you see in the third line of paragraph number 9 that you included a statement regarding sex acts performed to buy drugs?
Yes, I do.
Why did you include that statement?
I believe it was relevant to probable cause, that she was aware of what she had done, that she was aware of the substance she had taken, she was aware of how she acquired the substance. It also showed a state of mind that she had been compromised, potentially due to the effects of an intoxicating liquor or an opiate. And I thought it was relevant to the crimes that she had been charged with and potentially additional crimes that the district attorney's office may have been interested in pursuing.
I asked you to look at paragraph number 8. That's on the prior page. The second to last sentence that the arrestee says, "My dad's a blank judge, he's going to kill me." Do you see that?
I do.
Why did you include that statement?
I believe it shows an exhibit of remorse and immediate recognition that she was aware what she'd done was wrong, and also that it may have compromised my career due to who she was, given the facts from the bail commissioner that I was made aware of post-arrest.
Was the language in paragraph 8, was that the information that you included in paragraph 8, was that affected in any way with anything that happened after the arrest?
No, that's an accurate representation of what she had told me roadside at the cruiser.
What was your emotional state after you spoke to the bail commissioner?
I was concerned,
What were you concerned about?
potential repercussions.
Repercussions about what?
The defendant and her status, family status.
Is that why you put the comment in paragraph 8?
Can that lead to witness, please?
Okay, well, that's overruled. You can answer.
Sorry, can you repeat the question?
Would you please?
Question, is that why you put the comment in paragraph 8?
I believe it played into it slightly. I think it was relevant regardless, and it offered another layer of insulation.
Insulation regarding what?
Potential repercussions that I might face.
Now, the 3 statements that we've just discussed, in your experience, both as a Canton and Brewster police officer and as a Massachusetts state police officer, had you ever seen statements of this type in arrest reports before?
Yes,
After you wrote the report, did you take any action regarding the report?
Yes, I did.
What did you do?
I submitted it for review to a direct supervisor.
And do you recall who the direct supervisor was?
Yes, I do.
Who was that?
Sergeant Conan.
And do you recall, did you have any conversation with Sergeant Conant that evening about the report?
I was made aware that he had approved it after the fact.
How were you made aware?
He called the barracks to say that the report was all set.
Did you have any other conversation with Sergeant Conant regarding stipulated Exhibit 1?
Not on that day, no.
Once you were notified that Sergeant Conant approved the stipulated Exhibit 1, did you take any action?
Yes, I did.
What did you do?
I printed out the approved report and prepared an arrest packet to be submitted to the Worcester District Court.
Okay. Stipulated Exhibit 1 is, I think, 5 pages long. Is that correct?
Yes,
Were those 5 pages part of what you printed out?
yes,
Were there other things that you printed out?
yes.
What else did you print out?
Would have been a copy of the motor vehicle citations, the complaint application for criminal and driving history, as well as the vehicle information and her license information.
The complaint application isn't part of stipulated Exhibit 1, correct?
No, it is not.
When the complaint application is printed, is there any information on it?
There is.
What information is on the complaint application?
The district court or superior court, I should suppose, is eligible too, but in this case, the district court it's being sent to, and the pending charges that the officer or trooper are applying for. And there's also the narrative is included in it as well.
How does the narrative become included in the complaint application?
It's electronically moved from the narrative that you also see in this exhibit, and it's attached to that automatically with the records management system for submission to the court.
So you've told us that it's you printed the 5 pages that are stipulated Exhibit 1, copy of the motor vehicle citation, complaint application, and I think registry of motor vehicle history?
Yes, it would be the registry motor vehicle history for her actual license, her what's considered a KQ, which is her driver's history, her BOP, her Board of Probation's check, which includes the criminal history, the vehicle information, the complaint application, the citation, this arrest packet, and generally 2 or 3 copies of this are included as well.
When you say 2 or 3 copies of this, are you referring to stipulated Exhibit 1 that you're holding?
Yes,
Once you print all of those documents, what do?
they're put in a folder that's labeled with the defendant's name, and it's submitted to a court box that the appropriate court officer will shuttle from the barracks to the district court.
Who is the court officer for the Holden, who was the court officer in October of 2017 for the Holden Barracks?
I believe it was Trooper Dean Ricciardi.
And do you know what happened to the arrest packet after you printed it and put it in the folder for Trooper Ricciardi?
I do not.
Let's see, I'd ask you to look at the bottom of stipulated Exhibit 1, and you can see there are lines at the bottom of the report.
Yes.
And in the left-hand corner, what do you see there?
Trooper Ryan Sevier, ID number 4035 with a line above it.
And why does that appear on the arrest report?
The original copy will be signed by the arresting trooper.
Okay, so where does the signature go?
On top of the horizontal line directly above the trooper's name.
Do you sign every page of the report?
All the ones that have a corresponding line on the bottom.
Okay,
I believe this thing, everything but the tow sheet, I believe, has one.
okay.
I have the answer right back.
Answer, all the ones that have a corresponding line on the bottom. I believe it's everything but the tow sheet, I believe has one.
And to the right of your name at the bottom of the page, can you read what is printed at the bottom of this stipulated Exhibit 1?
The centered portion or all the way to the right?
The center portion, please.
Status, approved by Sergeant Jason Conant. ID number, I believe it says 2718, but the copy is partially cut off.
Okay. Is there anything in stipulated Exhibit 1 that indicates what time Sergeant Conant approved this arrest report?
I don't see a timestamp now.
Do you, as you sit here today, do you have any memory of what time Sergeant Conant approved what's been marked as stipulated Exhibit 1?
I do not. It would have been sometime that evening though.
And the, just so that I'm clear, the arrest packet that you described before, that happens before or after the report is approved?
The arrest packet is after it's approved. The pre-approved copies of what would be Exhibit 1 here would have a large watermark down the center of the page that says something to the effect of not an approved copy.
Okay. Once an arrest report is approved in the RAM system, may it be changed?
Yes,
How?
if the supervisor denies or kicks the report back for corrections.
In this case, once Sergeant Conant approved what's been marked as stipulated Exhibit 1, could stipulated Exhibit 1 have been changed?
Not once it was approved. I would have no reason to change it.
Have you ever seen an arrest report such as stipulated Exhibit 1 been changed after it was approved by a supervisor?
Never.
Do you know what happens? Strike that. Did you take any actions related to stipulated Exhibit 1 other than, strike that, after stipulated Exhibit 1 was approved, other than printing the arrest packet, did you take any other actions regarding stipulated Exhibit 1?
No.
After the arrest packet was prepared, what did you do next?
Would have submitted it to the court box where the paperwork goes for the corresponding courts.
Did you take any more action that evening regarding the arrest or the arrest report that is marked as stipulated Exhibit 1?
No.
What did you do next? Strike that. Do you know what time you put the arrest packet into Trooper Ricciardi's box?
I do not.
Did you continue to work after you submitted the packet to Trooper Ricciardi's box?
I don't recall the exact time it was completed. The shift that I was working would have gone until 11 p.m. or 2300. If there was remaining time, I would have continued to work. If there wasn't, that would have been the conclusion of the shift, and I would have started to drive back towards my residence.
Okay. Do you know, did you work the following day?
I don't recall.
When's the next time that you hear anything about the arrest report that's been marked as stipulated Exhibit 1?
It was either 2 or 3 days later. I believe it was the 18th of October, 2017.
And what happened then?
Someone was knocking on my front door.
And who was it?
Trooper Antoine Haywood.
And why was he at your front door?
He said I needed to get dressed and drive to Worcester.
Did he say anything else to you?
He did.
What did he say?
He said he wasn't sure what was going on, but something about the arrest from the other day, and I needed to get dressed and go meet at the Holden State Police Barracks.
And as a result of that, what did you do?
Looked at my phone and realized that I had a number of missed calls.
Were you scheduled to work that day?
I was not.
And after you saw the voicemails, what did you do?
Contacted my union representative.
Did you listen to the voicemails?
I did.
Madam Legal Advisor, I request to play what's been marked as disputed exhibit number 4. It's an audio recording.
That's your decision.
Oh, you just want him to look at it?
I want him to listen to it, Your Honor.
Oh, okay.
Does Arthur have the recording?
He does.
Okay.
Ryan, call me ASAP as soon as you get this message. You are to immediately code 7 to the barracks, per the colonel. That's an order from the colonel. It's got something to do with an arrest report, a judge's daughter. But you have to code 7 immediately, on overtime or whatever. But that's an order right from the colonel that you will code 7 to the barracks, and I'll find out more. But call me as soon as you get this message, please.
Is that recording an accurate representation of the voicemail that you listened to?
Yes,
Do you recognize the voice on that voicemail?
I do.
Who do you recognize it as?
Retired Lieutenant James Fogarty, the station commander at the time of C6 Holden that I was assigned to.
Your Honor, at this time, I move to admit disputed exhibit 4 as the next exhibit in the record.
Counsel? Me, want to be here? No, no, okay. What's that exhibit, what, 14, 16?
Thank you. Trooper Sevier, what does code 7 mean?
Report to your duty assignment, which would be whatever barracks you're assigned to.
And as a result of getting that voicemail, did you take any action?
I did.
What did you do?
I got dressed and I started driving to Worcester, Holden.
Do you know what time did you leave your home that day?
I don't, sometime in the morning.
How long did it take you to get to the barracks?
It's roughly an hour and a half from my house, dependent on traffic.
Do you know what time you arrived at the barracks that day?
I don't.
Please tell me and the commission what happened once you got to the barracks.
I met with Lieutenant James Fogarty.
What happened during that meeting?
He issued me a negative EES for the report.
Did you have any conversation with Sergeant Fogarty, Lieutenant Fogarty?
Yes, ma'am, Lieutenant Fogarty.
Sorry about that.
Yes, I did.
And what was the conversation that you had with Lieutenant Fogarty?
Not verbatim, but he said I did nothing wrong. He supports me. He said he didn't know why it was happening, but he had to give me a negative review. He said it's not a big deal. We'll take this out in a year. I'll take care of you. I'm your guy, something to that effect. And then asked me to sign it.
And did you sign it?
I did not.
Prior to your conversation with Lieutenant Fogarty, did you speak to anyone else regarding stipulated Exhibit 1?
My union representative, Jeff Gilbert,
When did you speak to him?
that morning.
Did you speak to him at the barracks?
He was at the barracks, yes. I did speak with him, yes.
Did you start that? Your conversation with Lieutenant Fogarty, how long did that take?
Roughly 5 to 10 minutes.
After speaking with Lieutenant Fogarty, did you speak to anyone else about what's been marked as stipulated Exhibit 1?
I did.
Who did you speak with?
Retired Major Susan Anderson.
Where did that conversation take place?
In her office at the same building.
Was anyone else present for that conversation?
Yes.
Who else was there?
My union representative, Jeff Gilbert.
What happened during that conversation?
Lieutenant Fogarty, to finish the last remark, had said, "I'm sorry you're handling it this way," something to that effect, and wrote refused to sign on the negative performance review. And he said, "You'll have to go upstairs and speak to the major in regards to this."
And did you go upstairs?
I did.
And then what happened?
I spoke with the now retired major, with my union representative, about the report.
And what did you speak about?
Spoke about the contents of the report, that needed to be changed. And at that point, she agreed with the contents of the report.
What did you say to her and what did she say to you, to the best of your recollection?
To the best of my recollection, I told her this wouldn't be happening if it was anyone else's child and if they weren't connected. And she said that's true, but it's not. Everyone has bosses, and this is how it's going to be. And this is from the colonel.
And did you and Major Anderson have any more conversation regarding stipulated Exhibit 1?
Yes.
What other conversation did you have?
She provided a piece of paper with annotations on it from a person she referenced as the colonel, with specific lines and information she wanted stricken from the report.
And after receiving that document, did you take any action?
I did.
What did you do?
Spoke to my union representative, and I asked him, "Is this a direct order?" And the retired major said that it was. And I asked Representative Jeff Gilbert, "What happens if I say no?" He said, "You potentially face insubordination charges, which can lead up to and including termination."
Did you take any action after that conversation?
Yes.
What did you do?
I recommended at some point that the report include annotations that it had been revised and was not an original copy, because it had already been submitted, and I didn't think that I could change it legally at the time.
And I would ask that the witness be provided with stipulated Exhibit 2.
Thank you, sir.
Good, thank you. Okay.
If you'd like to take a minute and look at stipulated Exhibit 2, let me know when you're finished looking at it.
All set.
Do you recognize stipulated Exhibit 2?
I do.
What do you recognize it as?
The revised arrest report.
Walk me through the steps from conversation with Major Anderson to stipulated Exhibit 2. What happened?
After this, I went to the report writing room at C6 to make the changes they ordered, and also articulate in the report that it was not an original copy, it had been edited from its original version.
Where did you put that language that
Page 2, the first line of the narrative portion, roughly the center of the page, centered on that page, prior to the first paragraph.
okay, can you read that?
Revised on October 19th, 2017.
Okay. And you made the revisions that appear in stipulated Exhibit 2, is that correct?
Yes.
After you made the revisions to stipulated Exhibit 2, do you have any information? What happened to the contents of stipulated Exhibit 1 in the RAM system?
The new version of the report will be submitted for review or pending review. It was submitted to a Lieutenant Pillsbury for review. That would have overwritten the original contents of the report to the best of my understanding of the electronic system. And it would replace the prior version, the original copy, with the new edited version, with an approval of Lieutenant Pillsbury as opposed to Sergeant Conant written on the bottom.
And you're referring to down at the bottom of stipulated Exhibit 2, the very bottom, that writing that appears kind of in the margin?
Yes, status approved by Lieutenant Donald Pillsbury, ID number 2569.
I just wanted to take a step back. When you went to the report writing room, did you have any documents with you?
would have had the annotations of what needed to be removed from former Major Anderson's order.
Was anyone with you in the report writing room?
Sorry, then Trooper Jeff Gilbert, the union representative.
Okay. How long did it take you to make the changes that appear in stipulated Exhibit 2?
A rough estimate of 15 to 30 minutes.
After you made the changes in the RAM system, what did you do next?
The report was submitted for review.
Did you have, take any action to submit the report?
I did.
What did you do?
In the records management system, when you have edited information, when you go into an approved report and attempt to edit it, it kicks it back. It's no longer an official approved document. I had to resubmit it, and a drop-down tab will ask why, so it'll be corrected information, et cetera. And that goes in for a new review to a supervisor. At this point, it was Lieutenant Pillsbury.
And you did that electronically, submitted it for approval?
Yes.
And once you submitted it for approval, did you take any action?
Once it was approved, I printed out the new version.
And I think stipulated Exhibit 2 is 1, 2, 3, 4 pages long, is that correct?
I have 5 here, but the 5th page is mostly blank.
Is stipulated Exhibit number 2, is that a fair representation of the arrest report as approved by Lieutenant Pillsbury that you printed out?
Yes, it is.
After you printed out the report, did you take any action?
Yes, I did.
What did you do then?
I spoke with Major Anderson again.
And what was the substance of that conversation? What did you say to her? What did she say to you?
She directed me to, ordered me to deliver it to a man named Jeff Travers at the Worcester District Court and meet with him directly to submit it.
Was Mr. Travers known to you at that time?
No, to my knowledge, I've never met him.
And as a result of your conversation with Major Anderson, what did you do next?
Drove to the Worcester District Court.
How long did that take you?
From the barracks, roughly 15, 20 minutes.
What did you do once you got to the district attorney's office?
Went downstairs to the basement portion of the first floor basement portion of the DA's office and spoke with the clerk there, or receptionist, and requested to speak with Jeff Travers.
Prior to leaving the Holden Barracks, did you take any other actions that you haven't described related to what's marked as stipulated Exhibit 2?
Not that I recall.
Do you know what time you left the Holden Barracks?
I do not.
Any idea what time you got to the district attorney's office?
Some point in the afternoon, I would guess, but I don't know the exact time.
Okay. And I think you said you went to the basement.
Yes, it was a portion of the DA's office I'd never been to.
And you spoke to, who, do you recall who you spoke to?
I don't. It was somebody who came to the desk.
And what did you do next after you spoke to that person?
I told them I needed to speak with Jeff Travers and drop off paperwork.
And then what happened?
They said that he wasn't available at that point, and they said they would get it to him, and I gave them the new packet.
Did you have any other conversation at the district attorney's office other than what you've described?
Not that I recall.
And is what's marked as stipulated Exhibit 2, is that what you delivered to the DA's office?
Yes, it is.
Was there anything else in addition to what's been marked as stipulated Exhibit 2 that you delivered?
Not that I recall.
What action did you take after you dropped the report off?
I left the court after that. At some point, I spoke again to my union representative, and they advised me to seek counsel.
Did you submit a request for overtime pay for hours worked related to stipulated Exhibit 2?
I did.
And did you receive overtime pay for that time?
Yes, I did.
Do you know how much time you spent on actions related to stipulated Exhibit 2?
I don't know the exact time, but from leaving my house to returning would have been a full day.
Do you recall, was your overtime pay more than $50?
Cumulatively, it would have been, yes.
When you say cumulatively, what do you mean?
At the time, my pay scale, I'm not sure if at a time and a half rate, each individual hour was greater than $50. I'm not sure what the exact number was at the time. But for 6-7 hours, however many it was, would have been north of $50.
Madam Legal Advisor, I'd ask you to please show the witness what has been marked as disputed Exhibit 14. And I believe that this was part of petitioner's motion in limine, and I believe that this exhibit has been allowed into evidence but has not been admitted as of yet. And I would represent that it is a letter from Colonel Gilpin.
Do you want me to show it to the witness?
Yes, please. Thank you.
Thank you, Sir.
Trooper Sevier, I apologize for the tiny print.
I'll do my best.
Do you recognize this document, disputed Exhibit 14?
I do.
Have you seen it before?
I have.
When did you see it?
Roughly 2019, probably 2 years or so after the initial arrest.
What is this document?
This is an apology letter.
Who's it from?
The then Colonel of the Massachusetts State Police, Kerry Gilpin.
And I'd ask you to read the second sentence out loud.
Independent investigators retained by the Massachusetts State Police concluded that your report in case number 2017-0C6-007699, the report underlying that lawsuit, was fully consistent with your training and experience and reflected reasonable professional judgment. As concluded by the independent investigators, you acted appropriately at all times during the arrest and investigation at issue.
And I just ask you, the report underlying the lawsuit, is that what's marked as stipulated Exhibit 1?
Yes,
And the letter refers to an independent investigation.
yes,
Did you participate in the independent investigation?
yes, I did.
Did you ever read the report that was generated after the investigation?
I believe I read portions of it. I don't think I've ever read it in its entirety.
May I have just one moment?
Sure.
Thank you. Trooper Sevier, I'd like to go back to the voicemail that we played earlier.
Yes, ma'am.
And Lieutenant Fogarty referred to a colonel in that voicemail.
Yes,
Do you know who that colonel was?
yes.
Who was that colonel?
Then Colonel McKeon.
And I just wanted to step back a minute. The difference, what statements were you ordered to take out of stipulated Exhibit 1?
I believe it was the 3 lines you had referenced previously in regards to the judge, the acquisition of the narcotics, and the proposed sex acts.
I have nothing further at this time, thank you.
Okay, one of the commissioners had, just sent us a question. Trooper, when you had that drop-down back box and you had a list of reason for the change, what was the reason you gave?
I believe it was corrected information.
That's what you just typed in or checked off corrected information?
Yes, sir. When you resubmit, you have to list the reason as to why the report was being resubmitted.
Okay.
To the best of my knowledge, I believe I checked corrected information.
Okay, great. Are you done, Mrs. Sutton?
I am, nothing further.
Do the parties want to take a short recess to confer or take a short break?
Like, because I see Mr. Bourgeois joined and I don't know at what point he joined, so I would like to take a break,
To speak with them?
to make
Okay,
sure.
so why don't we take about a 10-minute break?
Be great.
Okay, very good, thank you. Attorney Bourgeois, if there's anything you want to say, just, motion or something, and we'll see you, okay?
The only thing I want to say, sir, is that happiness is a short visit with your cardiac surgeon.
Yeah, that's true, you've defined it, you have defined it, so thank you. Okay, so at this point, Attorney Burke, cross-examination, thank you.
Good morning, Trooper.
Good morning, sir.
I'm Attorney Tim Burke. Have we ever met before?
I don't think so. Not that I recall.
And I'm representing Major Anderson.
I do.
When you met with her, she polite,
Yes.
soft-spoken,
Yes.
empathetic?
Yes.
I didn't, I'm just a little.
Yes.
Hearing. And if I can just understand, going back, you make the arrest about 7:35, right?
Yes, sir.
And you go through, you bring her back. The transmissions are made to the turret. You come back. There's the booking process, right?
Yes.
And then you have a conversation with the bail commissioner.
Yes.
Who's the bail commissioner?
I don't recall her name. I know it was a female.
All right, well, there's two bail commissioners, both are female, right?
Yes, sir.
And during that time period, you have the conversation with her. When was that? That was obviously before Ms. Bebo was released to the custody of her father. Right?
Yes.
And had you given the bail commissioner the information pertinent to making the determination as to what the bail should be?
Yes.
And during the time period that you're talking to her, was it on the phone or in person?
On the phone.
Did you have other conversations with her once she arrived there?
Yes.
Do you remember, just so we have the sequencing here, this incident happens on October 16th, right?
Yes.
The revisions are made on or about the 20th of October?
I think it was the 18th or 19th, but roughly in that area.
All right. And then you filed a lawsuit on November 7th, right?
I'm not sure of the date. I did file a lawsuit.
Okay. And that was against my client, right?
Yes.
Federal court.
Yes.
And I represented her in that case.
I'm not familiar.
The case was dismissed, right?
The federal case, yes.
Okay. And that was the lawsuit you brought against Sue Anderson, right?
Yes.
And when Lieutenant Fogarty spoke to you, he said that you were about to get an EES, right?
Yes.
And the EES is an evaluation of what some individuals feel is appropriate or good or bad, correct?
Yes.
And it's not discipline, is it?
I would argue a negative ES is disciplinary, yes.
Okay, you weren't suspended,
No, I was not.
you weren't given a letter of counseling, right?
No, I wasn't.
You weren't given a written reprimand, were you?
Again, I would consider a negative
just
ES a written
You
reprimand.
understand my question?
No, I don't.
Okay, it's a very narrow one. Were you given a written reprimand as opposed to an EES?
No, it was an ES, a negative ES.
Were you suspended from duty?
No, I wasn't.
Were you terminated?
No, I wasn't.
Were you charged with insubordination?
No, I wasn't.
Okay. And all throughout, when you were interviewed by the Attorney General's office, remember that?
Yes,
So just so we have the sequencing. Incident, the arrest takes place October 16th. You filed a suit less than 3 weeks later. Then you're interviewed by the Attorney General's office on or about December 17th, 2017. Remember that?
yes,
And it was kind of a lengthy interview. You had your legal counsel present with you.
yes,
And when you were being asked questions about the bail commissioner, remember that?
to the best of my knowledge, I do.
Okay. And have you read any documents in preparation for your testimony here today?
Just the initial report and anything else I could
Your
find.
first the initial police report?
Well, I'm sorry, the revised report.
Okay. And so then on December 17th, you're interviewed by several people from the Attorney General's office, right?
Yes, sir.
And they were doing their own investigation, were they not?
Yes,
And they found that none of the changes result in any change in the charges that were brought against Ms. Bebo. You knew that, right?
yes,
So there was nothing that was done in changing those 2 or 3 statements from your initial report that resulted in any change in the actual charges that were brought against her, right?
no, well, yes, that did not happen.
And you also know that she eventually admitted to sufficient facts, right?
Yes,
And was punished.
yes,
You have no disagreement with the punishment that she received, do you?
No.
All right, and did you know when you arrived back at the station? So you're at the Leominster Barracks, right?
be holding.
Hold it, I'm sorry.
No problem.
Yeah, and so you go back to the Holden Barracks, and you had been there for how long? You came on in 2015?
Was in the academy from 2015 till April of 16. I was in Millbury for 3 or 4 months. So I'd say a rough estimate of a year and a half
Okay, so you've been on duty for a year and a half this time, right?
with the state police, yes.
All right, but you had prior experience writing police reports before this, correct?
Yes,
Right, and so when you're there, you come back to the Holden Barracks, you knew when you got back there that the person you had arrested was the daughter of a judge, didn't you?
yes,
And you learned that from the dispatcher. So as soon as you got there, you knew that this was somebody who was the daughter of a judge.
yes,
And that made no difference to you in terms of what the charges were, right?
no,
And nothing in those revisions from the charges that you initially brought were altered in any way that as a result or consequence of those revisions being made, were they?
no,
Again, she ultimately admitted to every one of the charges that you brought. Isn't that true?
yes,
So when you were interviewed by do we have a copy of Trooper Sevier's interview with the Attorney General's office? Well, I think I do. Yeah, Judge.
Sure.
Oh, Trooper, I'm just gonna hand you what's transcript of your interview. It's with the Attorney General's office on December 17th, 2017. Remember that?
yes, sir.
So can I have you go to page 29? I'm gonna go through 2 or 3 pages, so go with me, all right?
Yes, sir.
You see at the bottom of the page, you're being interviewed by Mr. Mullen. He's an Assistant Attorney General, correct?
Yes, sir.
And you're, again, just so the scene is set, you're at the AG's office here at this building,
Yes, I believe it was.
and upstairs, 20th floor with your attorney.
It may have, I don't recall the floor number.
Okay, and they're asking you questions about your contact with the bail commissioner, right?
Yes,
And this, of course, your communications with the bail commissioner would have happened before she was released and before you had completed your arrest report, right?
yes,
Did I understand you to say that you put those statements in, those questionable statements, because of your concern as a consequence of what took place between you and the bail commissioner? You wanted to protect yourself and your career?
I did want to make sure I was safe, yes.
Okay, but did I hear you say that? You put those statements in regarding, well, one of the statements that was removed, what you put in quotes was, "You have no idea how many dicks I sucked to get this for us," end quote. That's one of the statements that was removed in the revised report, wasn't it?
Yes,
And is it my understanding that you put that sentence in quotes in paragraph 9 because you were concerned about your career?
I think we're referencing a different,
Hold on a second. As a consequence of your communications with the bail commissioner?
no, I think we referenced a different line when we spoke about that previously. I believe
Okay.
that was the line, "My dad's a judge, he's going to fucking kill me," or something to that effect.
Okay, so that was the other, my dad's a fucking judge, he's going to kill me, end quote, right?
Yes, sir.
So that's the only statement that you put in there that you say you did because of your interaction with the bail commissioner to protect yourself?
I was concerned at the time.
I didn't ask you your concern. Is that the statement you say you put in there as a consequence of your interaction with the bail commissioner?
No, I think those were added for a number of reasons, and that was a portion of it.
Well, correct me if I'm wrong, but didn't you say that you put those statements in quotes because you were concerned about protecting your career as a consequence of your interaction with the bail commissioner?
That was a portion of it, but it went into a number of other avenues as well.
All right, well, page 29, can I just read your answer?
Yes, sir.
They're asking you about, okay, so I think the pending question relating to contacting the bail commissioner. In your answer, quote, "So initially I contacted the bail commissioner and she said bail at $240 cash, which is $200 being the bail and the $40 being her bail fee. What happens traditionally is you call them in a separate room, them being the bail commissioners, right?
Yes, sir.
You advise them of the charges, the criminal history, and if they default. And if they default, if they fail to appear in court, normally based on their criminal history. In this case, Ms. Bebo, had one open case, no previous defaults. So I tell her, you're talking about the bail commissioner now, again, right? I tell the bail commissioner
Yes, sir.
that, and you tell her that the arrest information, the OUI, the crash. So she asked, was there a crash? Were there injuries? And I said, yes, crash, no injuries. And she said, okay, the bail is $240 cash.
Your Honor, I'm
$200.
gonna object. Is there a question?
I know.
I think he's getting to it. Yeah.
Then I would object to this line of questioning because the bail commissioner is not a respondent in this matter. What happened with the bail respondent doesn't have anything to do with this matter. The bail in this case is not an issue in this case. It's irrelevant to these proceedings.
Okay, that's overruled.
Thank you. Stay with me for a minute.
Yes,
So
sir. Can you
she
just
asked,
refresh me where you are now at this point?
yeah. Was there any injuries? And I said, yes, crash, no injuries. And she said, okay, the bail's $240 cash, 200 being the thing and $40 being the figure. So she, the bail commissioner, won't come down until the money is physically in the building. So Judge Bebo was contacted. Okay, so accurate so far?
Yes, sir.
And the next question, by who? In your answer, I believe by Ally, but I'm not 100% positive. I'm in and out of the room printing things out, and usually it would be the detainee, the suspect would contact somebody to bail money. Somebody contacts Judge Bebo, tells him $240. He comes down to the lobby of the barracks, walks in the front door, provides the desk officer with $240 in cash. Now that money is physically there. We contact the bail commissioner and let them know the money is physically there. Because a lot of times people will say they have money coming and it never arrives. Anyways, the money is there. We call the bail commissioner. She comes down. I meet with her to give her the money. And she is given a face sheet, which is just the sheet that has the booking picture, the charges, the location, and it's just some basic information of the arrest. She's given that, and then she recognizes the name of who it is. And she said, the bail commissioner, said, you didn't tell me this was Bebo's kid. And I said, you didn't ask. The next question. And did you recognize the name? Answer, I had no idea. I have never been to Dudley Court. I've never been a friend of that judge. I have never heard of him in my entire life. We have absolutely no history, okay? Answer, I was told prior to that, but after the arrest was made who it was, okay? And your next answer. But at that time of the crash and the arrest, I had absolutely no idea who she was or he was. So I told the bail commissioner, I'm sorry. She alerted me that, hey, this is Bebo's kid. Why didn't you tell me that? And
Your
I,
Honor, I'm going to renew my objection. The attorney is simply reading the transcript into the record, and it's not clear whether there's a question. He's not asking the witness any questions. He's reading the transcript.
Well, I think
It's not
he's-
an exhibit.
Okay, well, that's overruled. Go ahead, next.
with me again,
Yes, sir.
she alerted me that, hey, this is Bebo's kid. Why didn't you tell me that? And I said, I don't have to. I just have to tell you the criminal history, open cases, defaults. And she said, well, I'm going to give him his money back, being Judge Bebo. So she went to the front lobby and handed him back the cash that he brought in and got rid of the bail and let her go out on personal recognizance or PR. Have I read that accurately?
Yes, sir.
That's the substance of what you were concerned about or upset about by the fact that she gave him the money back, weren't you?
That was part of it, yes.
Okay. And up to that point in time, you had not put the statements in quotes in paragraphs 8 and 9 in your report, had you?
No.
Okay. And you clearly had probable cause available and built into your report through paragraphs 1 through 7, didn't you?
Had I established enough through the first 7 paragraphs that the remaining information isn't
Sorry to
necessary?
interrupt you. Do you have the, your original
I do.
All right, can you take a look at that?
Yes, sir. Just give me one moment to follow along with you. You're saying
Hold
the
on.
contents of the first 7 paragraphs negates the
Let's go
necessity of
through
8?
it. I'll go through it with you. All right, first paragraph, right?
Of the original unedited version?
Yeah. Either one.
Well, they're different.
I know, I'm aware. First paragraph, you're just telling you're dispatched to I-90, right?
190, not the
I'm
turnpike.
sorry,
This is
190.
the north and south road, Leominster to Worcester.
All right, 735, right?
Yes, sir.
Incidentally, was your original report kicked back by Sergeant Conant at some juncture when you first submitted it?
I would have to reference the initial interview. I don't recall. Was there a grammatical issue?
I'm asking you.
I don't recall.
Didn't he tell you that there is a problem with your identification of the operation? Who was operating the vehicle? And didn't he kick that back?
He may have. I'd have to refresh my memory. It's been almost 5 years at this point.
All right, so first paragraph, and then you go to the second paragraph.
Yes, sir.
You read through that?
The second paragraph?
Right. Let me know when you read through that.
All set.
So just looking at paragraph 2 and take that in isolation. Paragraph 2, if you are put on the stand and required to testify just to what the content of paragraph 2 is, that establishes probable cause independently, doesn't it? I mean, you got a car crash, she's lethargic, can't stand up. You got probable cause just in paragraph 2, don't you?
For an OUI, the minimum requirement for probable cause would be the odor of an intoxicating liquor, bloodshot and glassy eyes, and slurred speech.
You got that? That's in paragraph 2, right? You said to her, you asked her to open her eyes because they were bloodshot and her eyes are nearly completely closed. You got that, right?
Yes, sir.
Okay, you agree with me? You got probable cause right there in paragraph 2.
Well, it would also require a public way, which would be included in paragraph number 1, not 2.
Right. So in combine paragraph 1, paragraph 2, you got probable cause right there, right?
Operation, public way, and impairment.
Crash the car.
Yes, sir.
All right, so even though you might have been on the state police for a year and a half, you got all the background from your prior history, Worcester, Canton,
Yes, sir.
you know independently that's enough to have convicted her or
No, that would be enough to arrest her. To convict her.
okay, we'll
would
just
require
do the
her-
probable cause. We'll stay with probable cause.
Yes, sir.
All right. And then you go through your field sobriety test, right?
Yes, sir.
And your field sobriety test, pretty standardized training from the Highway Safety Organization,
Yes, sir.
all right? Are you an expert in horizontal gaze nystagmus?
No, I'm not.
But you did it anyways, right?
Yes, sir.
Right? So even though you're not an expert and qualified to testify about that, you put that into your report, right?
Yes, sir.
And I'm not criticism about that, but that adds another element to what your pre-existing probable cause was already established, right?
Yes, you can add it towards probable cause. I just personally wouldn't be able to testify to it in court.
Okay, but you'll also say under paragraph 4, I quote, I again notice a strong odor of alcoholic beverage being emitted from her person, right?
Yes, sir.
Right, so that's included in paragraph 4. That's independent of your horizontal gaze nystagmus, right?
Yes, it is.
All right, so then you do the physical test, right?
Yes,
First one, paragraph 5 is walk and turn.
yes, sir.
And you determined it to be at the last, you say, quote, I deemed this test to be a failure. So she failed that too, right?
Yes, sir.
And would you agree with me that adds one more component to your list of support for probable cause that already was established?
Yes, sir.
And we go down to the one-legged stand. She's swaying, raising her arms, put her foot down, right?
Yes,
And Ms. Bebo, then you said, began hysterically crying and screaming that she was sick and a heroin addict,
yes,
right? You put that in quotes there, and that actually does support the probable cause for operating under the influence of narcotic drugs, doesn't it?
yes, sir, it does.
Okay, so you've even added that to further the probable cause for the driving while under the influence of narcotic drugs, in addition to alcohol, right?
Yes, sir.
Now, and you also say, quote, I deem this test to be a failure, right?
Yes, sir.
So number 7, all right, and you asked a standard question. Incidentally, did you ask her to do the alphabet test?
Not that I recall.
Okay.
It's not one of the standardized tests for our OUI program. We generally just do horizontal gaze nystagmus, 9-step walk and turn, one leg stand.
Okay. A lot of other troopers do that though, don't they?
You would have to ask them.
All right. Do you know other troopers who do that?
I have seen troopers do that, yes. Sure.
So, and then paragraph 7, you asked her how much alcohol,
Yes, sir.
and in addition to that, you locate a yellow handbag, and it's a heroin kit, and it's in the back seat of the car, right?
Yes, sir.
So you even got more probable cause at that stage to support your charge with operating under the influence of narcotic drugs.
Yes, sir.
So when was this report submitted? You said it took about an hour to do it. When was it submitted?
At some point that evening. I don't know. the
Right,
exact-
I know. But Ms. Bebo and her dad leave the holding barracks at 10:17. You knew that, right?
I don't know the exact time offhand, no. If that's what was in the records, then
10:17.
10:17.
Okay. She's arrested at 7:35. They leave at 10:17. What time?
Objection. I'm not sure the
evidence in the record reflects what time Mr. Beagle and his daughter left?
Well, you can bring that up on courses with direct. Yeah.
We will be happy to produce the document, Judge, if there's any question. So your report, you got the boxes. When did you type in 8 and 9, paragraphs 8 and 9? I just finished with 7. Those are at the very end, right? Of your report.
They are at the end, yes.
Sure. So you would agree with me, those are the paragraphs, if you're doing them seriatim, they're the last ones to be
Sorry,
complete
excuse me.
in
I'm
order.
not familiar with Syrian.
Actually, I just use it smart, sounds smart.
Dumb it down for me.
In order,
In order. Understood.
so. Eight and 9 are done at some juncture after Mr. Bebo has left with his daughter, isn't that true?
Yes, sir.
And is it my understanding that in paragraph 9, you put in, she stated, quote, "You have no idea how many dicks I sucked to get this for us," end quote.
Yes, sir.
That's in the middle of, almost in the middle of paragraph 9, right?
Yes, sir.
And during the time period that you're writing this, you had just had your conversation with the bail commissioner, isn't that true?
Yes, sir.
When Major Anderson was speaking with you, Trooper Sevier, were you notified that this was a so-called direct order?
Yes, sir.
And you work in a paramilitary organization, don't you?
Yes, sir.
And you have an obligation to follow orders just like everybody else in the chain of command, don't you?
Yes, sir.
And did she tell you that she had been given a so-called direct order
Yes,
to
sir.
have these revised?
Yes.
She didn't tell you this was her idea, did she? She told you it was a direct order from someone in higher command to her.
Yes, sir.
And you were obligated to comply with that order, weren't you?
Yes.
Now, do you know, did you authorize anyone to release the content of either your initial report or the revised report to anyone in the media?
The media? No, sir.
And when did you learn that the original report you submitted had been impounded by the court?
Say that one more time for me. I'm sorry.
When did you first learn that the original report had been impounded by the court?
I don't recall.
You did learn that, didn't you?
The original unedited version was impounded?
Yep.
I was told that at some point. Yes, I don't recall when.
Did you know that it had been impounded at the time that you were speaking to Major Anderson? And she asked you to revise those 2 or 3 sentences?
I don't recall.
Do you know what an impoundment means?
I have a general understanding, but if you could break it down for me, I'd appreciate it.
Okay. It means it's not subject to public view.
Okay.
Did she tell you that was, or did you know that was the impetus, that it had been, a motion had been filed on behalf of Miss Bebo's attorney the day of her arraignment? Did
I
you
don't
know
recall
that?
that. No, sir, I don't recall that.
Did you know that was what brought it to the court's attention, asking that it be impounded because of its content?
No, sir, I don't recall that.
Do you know that now?
That you're telling me? Yes.
Okay, no, had you known it before me telling you?
I've heard that this report was impounded. I'm not 100% familiar with the legal process in that regard. It's generally not what a road trooper does day to day.
Right,
Just if you remember my place in the period of law enforcement, I'm certainly not dealing with the district attorney's office day to day in that regard.
okay. And just finally, sir, you would not have put those statements in there but for your interaction with the bail commissioner that night, is that true?
That's not true. I would have put them in. That was a portion of it that contributed to it as well, but I would have still included them.
You were angry with the bail commissioner, weren't you, because you thought she had given him preferential treatment?
I believe she did get preferential treatment,
The bail commissioner gave preferential treatment.
as well as others, yes.
Did you ever write any kind of supplement to voice your concern about what the bail commissioner had done?
I don't recall doing that now.
But in terms of adding something into your report, if it was a concern about your career, you could have put something into the effect of what had happened, your experience with the bail commissioner, couldn't you?
Are you asking if I logged or made a supplemental narrative
Sure.
indicative of the conversation with the bail commissioner exclusively? No, I didn't.
You could have done that, couldn't you?
I would have had to have gotten the report reviewed and submitted again, yes.
Okay, when you had to get it reviewed or not, you could have done that had you chosen to do so.
Yes.
Thank you.
Now, once again, I get one of my fellow commissioners asked me to ask you this question,
Yes, sir.
Trooper. Did you take notes to use in creating the police report?
Roadside, as things progress?
At any point prior to creating the police report, had you taken any notes?
I don't recall doing that, no.
You don't recall?
No, sir.
Okay, great. Okay, thank you. Okay, at this juncture, I'll ask,
John, I didn't know if there was an opportunity to redirect after Attorney Burke, but I was going to proceed across.
yeah, why don't you do, yeah, you can do the cross.
Looks like we're still morning. Good morning, Trooper.
Good morning, sir.
My name is Mike Briscone. I represent retired Carmen here. We've never met before, correct?
Not that I'm aware of, no.
Your Honor, at this moment, I'm going to just preface the cross. I'm going to ask you to be taking administrative notice of some statutes and model jury instructions and case law. Would you like me to read them now, or should I just address them as I go along?
I want you to do it as you go along.
Sure, let's just pick up where we just left off with the bail. You stated that you had relayed criminal history, defaults, of which there were minimal, and I believe whether there was a crash or not as a factor in your considerations for bail, correct?
Yes, sir.
And that's just what you consider at the station, right?
Well, I don't actually consider the bail. It's a bail commissioner. I just relay the information to him or her, and they establish if there is bail and the availability of the bail commissioner.
All right, so that's the only information that you gave the bail commissioner, correct?
Yes, sir.
And are you familiar with the bail statute 276, section 58B?
Not offhand, no.
Okay, so then you're unfamiliar with the fact that a magistrate or a judge takes into consideration somewhere around 24 factors when setting bail. You're not aware of that?
I'm not, no.
You're also not aware of Cromwell versus Brannigan, that in some cases, many cases, requires written findings based on that checklist. So you're not aware of that either.
No, sir.
I don't expect you to be. I don't expect you to sit in court and listen to these things every day, but you're not aware of those, right?
No, sir.
Okay. And when you relayed that the person that was under arrest was the daughter of a judge, you'd agree with me that that could factor into one of the 22 to 26 considerations a magistrate and a judge could take into consideration, and that this person is a member of the community and has ties to the community. Are you aware of that factor in setting bail?
Without
I'm
knowing
gonna object
the-
to that question because I think it's restating the evidence.
I'm not quite sure I understand the objection,
I'll
but
rephrase it.
let's, okay.
So you're unaware that ties to
You
the,
could break it down into shorter questions.
that's fine.
Well, if, you know,
I'm happy to, yeah. So you're not aware that ties to the community is a factor that a magistrate or a judge would consider when setting bail?
No, sir.
And you agree with me that someone whose family lives in the community, that's a tie to the community, fair to say?
The Community being where the arrest was, or the county, or where the
Where they
barracks is?
Where they live,
How big is the community?
where the courthouse is.
Do they live in Worcester? I'd have to look up their address. I'm not familiar with their residence.
If somebody lives within half an hour of the courthouse, is that a side of the community?
I would say so.
Okay. Same thing with their family, extended family, ties to the community, correct?
Yes, sir.
And again, I'm not criticizing you, I'm just saying, this is something a magistrate considers, so you agree with me that that is something that, in addition to what you originally relayed them, they now have additional information that they could potentially base their decision on.
Yes.
Thank you.
Can I just ask you to, just because, once again, I just got to note that one of the commissioners is just having a little trouble hearing you speak. So she asked if you could slow down or just keep your voice up or make it easier for her to hear, him to hear. Thank you.
Trooper, if we could go back to something you touched on. You stated that when you spoke to, is it Sergeant Conant or Lieutenant Conant?
Yeah, sergeant at the time. He may be a lieutenant now. At the time, he was a sergeant.
I believe your testimony was, I sent the report, I heard it was all set, that was that. I'm paraphrasing, I think, but that was basically what you said.
Yes, sir.
So, again, you gave an interview to the Attorney General's office in connection with this that we've been referencing.
Yes, sir.
And you're aware that Conant also gave an interview at the Attorney General's office?
I am.
And so, are you aware, one way or the other, that Sergeant Conant?
Objection.
Yes, it answer the question.
Well, I'm afraid he's treading very close to asking a witness to comment on the credibility of another witness.
Well, he hasn't asked the question yet, so I agree with you, that might be an improper question, but I just ask you to let him finish the question, okay?
Are you aware that Sergeant Conant informed the Attorney General's office that the report that was submitted to him originally needed to be sent back?
I'm not aware.
Objection.
What's your objection?
He's asking the witness to comment on the credibility of
No,
another
no,
witness.
Okay, I disagree, okay, that's overruled.
So
I
you're
haven't
not,
read his attorney general's.
well, I didn't ask if you read it. So let me back this up then. The testimony is that Sergeant Conant didn't send back a report to you to be revised when you initially sent it.
Not for the lines at hand, if you're referencing.
I'm not referencing those. The first time you submitted the report.
I don't recall if it was kicked back initially.
So you don't recall Sergeant Conant kicking it back to you because you weren't specific enough on the operation element of the offense?
I didn't recall, no.
So I'm sorry, you don't recall that he asked you to be more specific as to how you identified the operator?
I don't recall that.
Okay. Now, moving on, in that vein, you were trained in the National Highway Traffic and Safety Administration materials and guidelines. You testified to that, right?
Yes,
Right, and person who trained you, you stated was Trooper McKeon.
yes.
And have you had an opportunity to watch any of the testimony before you were here today on Zoom?
From this hearing?
Yes.
No.
Are you aware that Trooper McKeon has testified in this matter?
No.
So as you sit here today, you have no idea who came before you, right?
Yes.
So, Trooper McKeon was your instructor. So you're instructed that, when you're making an arrest or forming probable cause, you have to hit the elements of the offense, of which there may be several, that's fair to say.
Yes.
With respect to OUI alcohol, the elements of the offense are operation, public way, and kind of impairment, but impairment's two-pronged with alcohol, right?
Yes.
Per se, which is 0.08, and then you have just impairment, which is your observations based on standard field sobriety testing.
Are you talking administrative penalties or criminal? The RMV has a different threshold.
I'm not talking about the RMV, I'm talking about.
Okay, so we're not talking breath test. Correct. If you're referencing the breath test, the 08 is per se, you are impaired.
Correct.
There's a window from 0.06 to 0.07 that you can still consider impairment, and south of that is released forthwith.
That's all I'm getting at. The elements of the offense to sustain probable cause and further a trial, proof beyond a reasonable doubt to a moral certainty. That's what I'm getting at.
Yes.
So evidence of 0.08 or above with an inference between 0.06 and 0.07, that is based on the per se law, right?
Yes.
And then if you don't have the breath test for any number of reasons, you have just your observations in the field of whether they might be impaired, correct?
Yes.
So there's two ways to prosecute an OUI alcohol case, right?
Yes.
And subsequently, or I guess in conjunction with that, OUI drugs shares the first two elements, operation, public way, But the way you prove impairment is different, fair to say?
Yes.
Because you don't have a per se law with respect to OUI drugs, at least as we stand here today, right?
Yes.
And you'd agree with me that, actually, I'll step that back. When you're if you don't establish any one of those elements in your initial report, that's grounds for dismissal, is it not?
Yes.
And I'm not expecting you to remember the court case, but you're familiar with Four
I'm
Corners.
not familiar with it. If you don't mind, just.
No, it's fine, because I don't want to say something that's gonna.
No, please, I haven't finished my JD or started.
Right, so you're familiar with the practice that an attorney can file a motion to dismiss on your paperwork alone if the elements are not specifically addressed appropriately.
Okay.
I'm not asking, okay, I'm asking, do you
Yes, I'm
understand?
familiar, you need the elements.
And additionally, if you're at trial, you've testified in OUI trials, right?
Yes, I have.
Have you ever been in a trial where someone moves to what's called a directed verdict under Rule 25?
The term sounds familiar. Again, you would have to give me a description or an example.
So you got a jury, you got a judge, defense attorney.
Yep.
Isn't it a motion for a required finding?
That's what it is, I believe it's Rule 25, yep. Where the jury hears the evidence, but the witness doesn't hit one of the elements, and the judge takes it out of the jury's hands.
Reverts back to a bench trial where he's.
Well, he just, is it not guilty on the spot? Are you familiar with that at all?
I am. I have heard that before.
Okay.
I don't know every single detail.
All that to say, you gotta hit the elements right out of the gate.
Yes.
Obviously, OUIs vary in all shapes and sizes. Some have very little evidence, some have very strong evidence. And I think you'd agree with me, we can't always predict what a jury is gonna see as important or not, fair to say?
Yes.
Okay. So nonetheless, though, you're trained that when you make these observations and they relate to probable cause, you should be including them in the report, correct?
Yes.
And I believe you had stated at some point with the Attorney General's office, things that you see defendant's statement should be in quotes, correct?
Yes.
Okay. Do you have with you that, I think it was Exhibit 1 that we had been referencing the report?
I do. The original report one.
Original or revised, I think either one's fine.
Okay. I have Exhibit 1 here.
Okay. So as we go through the report, paragraph 1, you observed a single vehicle that was involved in an accident, hit the right shoulder of a concrete guardrail, right?
Yes, sir.
That's something that would go to impairment, correct?
Yes.
And it would also
Operation.
go to public way,
Yes.
so, and that's an observation, obviously, that's not a statement, that's just something you saw.
The crash?
Yeah.
Yes, I didn't actually see the crash physically occur. I just.
You saw that it happened. What I'm saying, someone didn't tell you that the crash happened, you saw it yourself.
Correct. I saw the remnants of the car, et cetera.
Now, we go down to paragraph 2. The defendant, I'm just gonna refer as the defendant,
Sure.
had already exited the driver's seat, stated she was the driver of the vehicle, and the sole passenger identified her as the operator, right?
Yes,
So that establishes operation, does it not?
it does. Yes.
Pretty important in DUI case, fair to say?
Yes.
Okay, that's not in quotes though, right?
I'm sorry, what?
That's not in quotes, is it?
Which portion?
The portion we just went over. You said there's a
The
statement,
defendant being identified by Mr. McLean?
stated she was the driver of the vehicle.
Correct. I don't think she said I was the driver of the vehicle. If to the best of my recollection was something I was driving,
Right.
it was me, I crashed, something like that.
So this is important though, when you're writing a report, it's important to include important and pertinent points contemporaneous with what's going on. So they're fresh in your mind when you can review your report later on. Is that accurate, the reason for including these specific factors in a police report?
Yes.
But you didn't do that there, you just paraphrased, right?
It might have been if I couldn't remember the direct quote, I would paraphrase
Right.
to the best of my ability.
I'm not criticizing, I'm not saying paraphrase, it's not appropriate to establish probable cause, I'm just saying, you paraphrase there, right?
Yes.
And then, you made observations about glassy and bloodshot eyes. You asked her if she used heroin. She stated she had done heroin at approximately 9 a.m. on this date. So that's gonna go to consumption, which, again, would factor in your impairment, correct?
Yes, sir.
That's not a quote though, is it?
It's not.
Again, you're paraphrasing, right?
Yes.
Again, not criticizing that practice with respect to that, it's sufficient for probable cause.
Yes.
So again, you spoke with the passenger. He was sent on his way for reasons that really aren't relevant. Now, you conducted some field sobriety tests, at least you called them field sobriety tests, correct? In paragraphs 4 to 6.
Yes.
Now, again, going back to, Your Honor, if I could have Your Honor take judicial notice of the, let's see. I believe it's Model Criminal Jury Instruction 5.400. That's pursuant to GL 90, Section 24, operating under the influence of drugs.
Sure.
We have copies of this? Copies?
I've spoiled you.
You have?
I think it's my understanding that they're gonna be furnished at some point.
Well, my intention is to provide them, whatever they are. But I think a statute is something that any trier of fact can take notice of without it being provided.
Yeah, I mean,
It's
somebody
not a
can,
statute though, it's a model
Well,
jury.
don't argue with them. If you have a comment, it's directed to me, but
Sorry, Your Honor.
Mr. Attorney Kiley is correct. You know, out of courtesy, I think of it to us and to everybody, he's gonna furnish a copy, but he doesn't have to. Go ahead.
the statute is referenced in Model Criminal Jury Instruction 5.40090, Section 24, again, OUI drugs. And so in these jury instructions, there's a court case that's incorporated. Are you familiar with Commonwealth versus Gerhardt?
I'm familiar with the name. Can you give me a brief summary?
It's a court case that states that field sobriety tests must be referred to as roadside assessments. Are you familiar with that?
In regards to narcotics, it's opposed to an OUI liquor.
Yeah, but so you're unfamiliar with the fact that if you're gonna charge them together, then they must be referred to as assessments, right?
Did I reference them as field sobriety tests here?
You write in your report you do. I'm just asking if you're familiar with the law. That's it.
I am, yes.
So, again, in your report, you refer to these as tests, and you refer to them as pass-fail, correct?
Yes,
Right. And you would agree with me that, again, McKeon was your instructor.
yes, sir.
So would it surprise you to say that he would never instruct anybody to list something as a pass-fail or a test in a report?
That's overruled.
I've actually heard it both ways. I've had people tell me that you have to incorporate that and that you shouldn't.
Right, but McKeon's the one that trained you though, right?
Yes.
Now, again, I believe we can turn to your AG's interview if you feel like you have to, if you don't remember.
I haven't referenced it and it's been, again, almost 5 years, so I'm gonna need to reference it.
So you told the Attorney General, in crimes like OUI, there's often very little hard factual evidence. Do you recall that?
I'd have to reference it. Do you have a page number and line I can refresh myself with?
Page 7.
And what line am I looking at, sir?
And it'll be starting with line 17.
Starting with 17. Yes, sir.
Okay, so here we have, stop me if I'm wrong, we have a car where there's a crash, right?
Yes,
I'm sorry, we have an incident where there's a crash. You found needles in the car, correct?
yes,
The passenger identified the operator, fair to say?
yes,
Operator admits to operation, right?
yes.
Public way is not
I'm
in question.
sorry, you're gonna have to slow down for me.
Sorry. I think even when I'm slow, I talk fast. Where would you like me to restart?
I have the passenger identified the operator, fair to say. Answer yes, start here, please.
The operator that admitted to operation, is that accurate?
Yes.
There's no debate about public way, right?
No, sir. It was on a state highway.
Signs of impairment on the HGN, correct?
Yes,
Again, not something you can testify to, but something that would establish probable cause, right?
yes,
Impairment on the 9-step walk and turn, right?
yes,
Impairment on the one leg stand, right?
yes,
She admitted to using heroin that day, fair to say?
yes,
She admitted to consuming alcohol, did she not?
yes,
Glassy bloodshot eyes?
yes,
Your quote, immensely strong odor of alcoholic beverage.
yes.
Now, do you recall administering a breath test?
I do.
Do you recall the reading on that?
It was a .22 was one of them, and a .23. I think it rounds down to a .22 on that. I'd have to reference it. It should be on the bottom left corner
Right,
of the face sheet.
that sounds right.
Okay.
Fair to say that's almost 3 times the legal limit.
Yes, it is.
Are you familiar with the 24Q program when you blow above a .20?
I am not, no.
Then we'll leave that alone. Do you recall saying to the Attorney General's office that she gave tons of evidence against herself?
I would have to refresh my memory again. I'm not gonna remember any direct quotes from that. It's almost 5 years and I have not read this since.
I can appreciate that, no problem. Just give me 1 second. I'll tell
Sure,
you.
if you just want to let me a page and a line, please.
Page 75.
75.
Start on line 14. Did I refresh your recollection at all?
Yes, sir.
So she gave tons of evidence against herself on her own. That was your recitation to the Attorney General's investigators?
Yes.
So scrolling down a little bit more, referencing the statements we brought up earlier that were redacted. I believe your answer was, why was that in the report with respect to the judge's daughter? You see that there?
Yes.
Said your answer was, I think it establishes her mindset, that
Yes.
she knows she's guilty, right?
Yes.
Now, is that training you received from the National Highway Traffic and Safety Administration, materials and guidelines, or is that just your personal observation?
If somebody identifies their father as a judge,
It's just your personal take on it? You think that that's
no, I don't think they specifically reference that exact situation.
it's in the training, right?
It would not be in the training. That's what you're saying, correct?
I'm saying that your consideration that somebody remarking that their father was a judge, or I guess of any profession, is somehow indicative of her mindset.
No,
That's
not
not-
specifically.
So, okay. So again, her father's profession, that's not evidence about probable cause, right? I mean, it has nothing to do with public way, nothing to do with operation, nothing to do with impairment.
I think it's indicative that she's aware what she has done was illegal at the time, and it shows her mindset
Again,
is carrying some guilt and may not have been consistent with someone who was sober. Probably wouldn't make a statement like that. Why would your dad kill you if you hadn't broken the law or driven drunk or high, et cetera, or both?
and you needed her to tell you that to figure out she was drunk.
No, I just didn't know there was a cap on probable cause. I thought it was appropriate to continue to add to that vessel
Okay.
until I can approach beyond a reasonable doubt so that the district attorney's office could have successful prosecution.
Again, that's not something you're trained in, all right?
Not that line specifically, no.
Thank you, that's all I was getting at. Now, as far as the statement itself about, we're gonna move on to the other statement that appeared in paragraph 9 that I won't reference.
Yes, sir. And what page is that on? Or the original, we're back to the report? Or the
I'm sorry to keep
AG's?
you going back and forth.
That's all right.
We're going
Just
back to the
keep me
report.
apprised so I can follow along.
No problem, I can appreciate that for sure. So paragraph 9. Again, the statement, the one sentence in your entire report that does appear in quotes. You see what I'm talking about?
I think in paragraph 8, my dad's a fucking judge, he's going to kill me was also in
All right, well,
quotation.
I'm sorry, 2.
And I think in paragraph 7, 2 nips was also in quotation.
Is that a sentence?
Well, how
Is it
thin do you want to
sentence?
split this? It's
Trooper, I'm asking a simple question. Is 2 nips a sentence?
2 nips.
Is there a period after it?
I mean, there is a period after the quotation here, but it is the end of a sentence.
I don't want to get into
think
a grammar speaking class here. Is 2 nips a statement or is that a sentence?
Okay, 2 nips, as far as I'm aware, is not an entire sentence
Thank you.
with a subject verb going here.
Okay,
Uh,
okay, I'll clarify this for you so we can.
Sure, I'm sorry.
Well,
If
thanks.
we're going number of quotations or more, if it's complete sentences, I would have to look in.
Paragraph 9, there is a sentence in quotes.
Yes, there is.
And as we discussed, we went through the entire first couple paragraphs of your report to establish probable cause, and none of those were quoted. This one's in quotes. Do you know which one I'm talking about?
I do in paragraph 9.
Thank you.
I just need to go through the entire report. and
Well,
make
we've
sure
already
I
gone
got
through it. I mean, do you really want to go through it again?
I think my dad's a fucking judge, he's going to kill me is a complete sentence, and that's in quotes.
Okay, well, then we have 2 in quotes.
Okay,
And that, again, is not related to probable cause, right? You know,
I think it was.
and you're fine. We're gonna move on to what I'm trying to get at here. which
Okay, I'm
is
sorry, continue.
Paragraph 9, which is in quotes.
Yes, sir.
There's a sentence that precedes that. The defendant admitted to using heroin on this date, stated that she acquired the heroin this morning for her and for her boyfriend.
Yes, sir.
Now, would you agree that's an appropriate statement to say someone used heroin, at some point possessed it, and was aware that they used it?
Yes.
Because he had stated that this quoted sentence says, it shows the substance he's on, she was aware it was heroin, she was saying how she got it. That was the reason why you included that quote.
I think it adds veracity to my prior sentence as to how did I find her statements legitimate, that she knew it was heroin, how
I'm
she.
not asking
acquired
about
it,
what you
et
thought
cetera.
your veracity was, I'm just asking you what you told the Attorney General's office.
Yeah.
I would just, you know, because I think the court report's having some trouble when he's talking and you interrupt him. So I would just ask as best you can, you know, ask him the question, let him answer it, and then you can respond. Because I just think the court report's having some difficulty when, you know, people interrupt one another.
So my question was, that sentence before the quotes,
Yes,
you'd agree with me that establishes everything that you're trying to establish with the quoted sentence, right? It establishes the substance, right? She says she acquired heroin. You disagree with that?
no,
It says she was aware it was heroin. Do you disagree with that?
no,
Says how she got it. I mean, how she got it is how someone acquired a substance related to probable cause.
not for the OUI.
Thank you. Now, at some point, when we went through the bail stuff,
Yes,
I think we need to go through it again, but you did reference that there was a point in time where you were waiting for her to be bailed, right? And you went into some commentary about when someone would have medical attention sought for them. Do you recall that?
no, again, I'd have, anything in the AG's report, I'm going to have to read.
All right, well, you know, aside from the AG's office, in general, when you have somebody at the barracks, some issues may come up, right? You're trained as a first responder, right?
Yes, sir.
So if there's a medical issue, you don't just bail somebody, you call an ambulance, you address the medical issue, right?
What's the medical issue?
I
If
don't
it's
know.
a cold, probably not. If they're dying, yes.
Right, okay, easy enough. What about if someone's sick, someone vomiting, someone like that?
No, people throw up pretty frequently, unfortunately, especially with OUIs.
Right, but if it's not as a result of an OUI, you wouldn't look into it further to see if there's another issue there?
If vomiting isn't the result of an OUI, would I look into it further?
If somebody is vomiting in front of you and they're not arrested for OUI, would you call attention to it? Would you call an EMT?
Potentially, if they told me they had the flu, probably not. If they had
Just
no
asking.
symptoms and no indicators, yes.
Okay, now, as part of your first response training, I'm sure you're trained with respect to people that are dependent on drugs and alcohol. Is that accurate?
Yes, sir.
Are you trained that people that are withdrawing from benzodiazepines can suffer seizures from withdrawal? Are you trained in that?
I'm not familiar with that offhand.
Are you familiar with the fact that people that are dependent on alcohol can suffer seizures if they're withdrawing from alcohol?
She was drunk at the time. She'd just blown a
I didn't ask you
.22.
that. I asked you if somebody was withdrawing from alcohol and suffered a seizure, is that a medical issue? Just asking you that generally speaking. And are you familiar with people that are withdrawing from other substances such as heroin? Are you familiar with that they can suffer medical issues as a result of withdrawal?
Yes.
Okay. Now you referred to, I'm going to refer to the Attorney General's report. Give me one moment. Do you recall telling the Attorney General that you didn't seek the need for medical attention because she's just a drug addict?
What was the page and line on that, sir?
Give me one moment, sorry.
Try 27.
27?
So page 27 or line 27?
Page 27, line 8.
That's it.
27, 8, thank you.
Yeah, line 8, line 9.
Yes, sir.
Okay, so do you recall saying that now, that she's just a drug addict?
Yes.
Okay. And if we could move along into, you said it's common practice in narcotics investigations that you ask questions about who, what, where, as far as drugs were acquired and things like that, right?
Is this on that page as well?
No, it's, I'm just asking you in general, is that common practice?
Yes.
Okay. So in this particular case, do you recall saying you thought it was important to ask the who, what, where to see if they could go up the chain to get a bigger fish or anything?
Yes.
All right, but you didn't do a follow-up on that, did you?
Did I speak to her after this?
Did you speak to anybody after this with respect to taking out further charges for any other offenses?
No.
And you'd agree with me, if you're conducting an investigation into something outside of this OUI, to drugs, narcotics, prostitution, anything like that, that wouldn't be something you want made public right away, right, if you're conducting an investigation?
No, I would not want it public.
Right, but you submitted a police report where you stated that this might be important for those purposes into a probable cause statement that would become public, right? I mean, that quote goes to the courthouse.
Yes.
It would become, okay.
This is before it was impounded was the term, I believe.
Yeah, well, you didn't know it was gonna be impounded when you wrote the
Correct.
report, right? All right.
Correct.
Now, you said, if we go on to your familiarity with the DA's office, you stated that a first assistant would never handle an OUI.
I don't believe they would. I've never dealt with one. I've generally dealt with a very new person fresh out of law school for an OUI, especially a first offense.
Right, so when you're in there, you're not familiar with how the DA's office delegates who, what, and where, of who's handling what, right? It's
Not
just-
officially, just my anecdotal experience has always been a newer person
Sure.
based on the severity. And, you know, if you had a murder, I don't think someone fresh out of law school would handle that.
I don't think that would be.
Somewhere in between there for everything
No,
else.
yeah, I think I agree, that's probably not great practice. So, if we're gonna get to the, just want to touch on the EES report, the observation report. You testified that in your opinion, it's a disciplinary reaction, adverse employment sort of thing.
Yes, sir.
Okay, and you're aware of a court case that states that that is not the case?
I'm not. Can you explain that? Is it a
I'm just gonna,
state police internal?
so you're not aware of Johnson, of the Downey Johnson case, docket 1884-1875, it's a civil case, Your Honor, I'd ask you to take judicial notice of that, and I'll provide.
I'm familiar with Trooper Downey and Johnson.
So you're not familiar that the court made a decision that,
When was that adjudicated, before or after this?
I don't think it really makes a difference.
I couldn't have known before.
Well, let's put it this way, you're not familiar with the court's ruling that a observation report is not an adverse employment. It's not an adverse employment action.
I'm not familiar. I do think I know the two troopers in that case, but I'm not familiar with that.
Right, so again, your opinion is that it's a negative, that it's a disciplinary action, so you're not familiar with the court case saying that it is not a disciplinary action, that's all I'm asking.
Okay, no, I'm not familiar with that.
Now, as a result of this observation report, are you aware under, again, I'm gonna ask, Your Honor to take administrative notice of MGL 22C, section 43? Does that ring any bells to you at all?
Yeah.
So you're not aware that you had an avenue to appeal that to the colonel and subsequently to the Superior Court if you felt aggrieved by an observation report?
No.
So obviously, you said you spoke to an advocate, was it Gilpin?
Gilbert. He was a union representative.
Right, and he never mentioned that to you?
No, I don't remember an appeals process, no.
Okay. And I think Attorney Burke had already discussed this, I just want to make sure I don't miss it. You didn't get placed on leave, didn't have your pay cut?
No.
Didn't get demoted or anything like that?
Nowhere to go.
Right.
No,
You didn't get fired?
no, I was still employed, thankfully.
But you testified to the AG's office that as a result of this observation report, you weren't required to do any further education or training, right?
I was, actually. I had to go back to an OUI refresher course with a number of classes at some point after that. Don't have the date.
Can you turn to page 87 of your Attorney General's?
It may have been after this AG interview. Said 87, sir?
Yes.
And what was the line?
I'd say starting with starting with line 10, and then the first word of line 15. References any further activity by the state police to educate you or assist you with your report writing. You replied, never.
Correct.
All right, so this interview took place pretty, what was it, about a year after or so?
I don't have the date this was. I think it was more, let's see if it has this, December 17th. So it was only 2 or so months after the arrest. Actually, it looks like 2 months to the day nearly. There was, again, an OUI refresher course shortly after that was taught to me, but I think it may have
You get those a lot though, don't you?
emphasis. No, never like that.
You never had a OUI refresher course?
Never in this avenue. This was unique in the sense that it seemed to be,
Well, that's
like,
just-
this was the catalyst that spurred that.
And somebody told you that and put that in writing?
Put it in writing, no. I think it was very clear as to why I was there.
And if it wasn't in writing, how is that clear?
I think actually the instructor started the course by apologizing to me at New Braintree in the academy when I was sent back there with a number of other people.
All right, but again, at least with respect to your testimony, you told them you had never had any training, so I think, give me 1 second, Your Honor. Let's go back to the observation report. Do you recall what was said in the report?
The observation report?
Right. Brief, wasn't it?
It's only a line or two. It was something to the effect that the report was alleged to be inappropriate and needed to be corrected.
And it was inappropriate because it didn't go to probable cause of the elements of the offense, right?
Do you have a copy of the actual, yes? The original one?
I believe I do, if you want.
Okay. Yeah, I haven't read the original version in a number of years, if you don't mind.
You know, like I approach, sure.
Thank you, sir.
No problem.
Is this an exhibit by any chance?
It's not.
I don't believe so.
Am I okay to read this?
Sure.
Sure. All set.
Do you, now that your memory has been refreshed, do you recall the colonel's order saying, or the observation report saying, these statements were not elements of the crime, they did not contribute to probable cause, inappropriate commentary shall not be included in future reports, right?
Yes.
Does that say inappropriate comment will not be included in future reports for certain individuals?
Yeah.
All right, so to you, this means everybody going forward, don't do this again?
Yes.
And again, he references a gist of the report. Do you recall just reading that?
The gist being the narrative?
Gist, are you familiar with the term gist?
I am. In this case applied here, is it referencing the narrative of the report?
I'm just saying, it says included within the gist of your report. Do you take that to mean a brief summary of the facts and the elements?
I would say in the report that they didn't want those expletives used again.
He says the gist of your report. I just want to make sure that
Yes.
that's clear. All right. Give me 1 moment. I don't think I have any further questions, Ron.
And once again, I have a few questions from my fellow commissioners. Trooper, have you seen similar comments in other police reports?
Yes, I have.
Okay. And if so, how often does it happen?
I can't give a percentage of reports that contain expletives or things that may not be pleasant to read. But no UIs, it's very common. There's generally a lot of violence, reference, sexual things. Just people are impaired and they're generally not thinking very clearly and make things that are unfortunate and don't read well the next day, but are relevant to the report and the prosecution.
Okay, and the second to last question, how often are arrest reports in your experience edited?
That's very important to split in two portions. The first being an initial edit is relatively common, generally grammatical issues, or like the gentleman had referenced, if I hadn't identified the operator specifically enough, that would be an appropriate review where you would submit it. That direct line supervisor wouldn't approve it right away. You could either deny it or just speak to you directly and have you edit that portion rather of the narrative immediately and either resubmit the narrative if necessary, or he can just go in and approve it. In terms of a case like this, where an approved report is edited for its contents, I have never once seen it happen.
And another question, why did you include in the report how she got the heroin?
I think it was important, again, that she knew what she got. She made it clear as to how she acquired it, which gave her the legitimacy in her statement that this is a product that I had for this purpose, and I was aware of what it was at the time.
Thank you. Anything else, Ms. Rusconi?
No.
Okay, thank you, sir.
Maybe I'll be brief. It is almost 5 years since the arrest, correct?
Yes, sir.
And the interview you did with the Attorney General was literally December 17th, 2 months after the arrest of Ali Bebo, correct?
Yes, sir.
And as you've been here today, has your memory been refreshed as to whether you had a discussion with Sergeant Conant about the operation issues with respect to the young lady on October 16th?
It's been referenced a number of times, and I don't specifically remember the conversation in detail. It would have been a reasonable and commonplace discussion or interaction to have with a direct line supervisor.
Are you, on the day that you were addressed by Major Anderson, when you went to meet her, you met Sergeant Conant, didn't you?
Yes, he was at the barracks as well.
And you understood that he was also receiving an observation report, weren't you?
Yes.
And it related to his approval of what, of your, I resist calling it the original report, because I believe there to have been a prior draft that may have been shared with Sergeant Conant. So you understood that it related to Exhibit 1.
Yes, sir.
Thank you. And you understood, therefore, that you were not the only person to whom an observation report, an EES, was being administered with respect to what should happen in the future, correct?
Yes.
And when you went to the class that you just discussed with Mr. Rusconi, there were other people in that class too, correct?
Yes, sir.
And I know you told Mr. Rusconi you're unfamiliar with Chapter 22C, Section 43. Are you familiar with any of the statutes that deal with the colonel's authority under Chapter 22C?
Not offhand.
With respect to training, the training that you received, Trooper Nigerian did not teach you about complaint application process in the courts, did he?
Yes.
Your training with respect to what happened in putting together a complaint package to go to the court, to be filed, is that largely field training?
Yes, when you get sent to a specific barracks, you generally meet with the court officer, whoever handles that paperwork being shuttled to the appropriate court. And they give you a breakdown. Everyone's a little bit different on what they want, the order of the paperwork, if they want it stapled, or a lot of people prefer it to be paper clipped together so that it can be faxed or duplicated, et cetera. So there's minute differences wherever you go.
You've been assigned, let me step back in time. You were first an officer in Worcester.
Yes, sir.
Was there a single court officer when you were there in Worcester?
Don't recall there being a full-time court officer, only because it was a smaller summer town where it'd be difficult for a 21-man or so department to justify a full-time officer exclusively handling that workload. But there was, I believe it was a lieutenant at the time, that was responsible for that, in addition to a number of other duties, and that was a portion of it.
When you were in Worcester, did you yourself go to court? to be the complainant in district court matters?
No,
You then worked in, and I get confused.
Canton, don't worry, sir,
Well,
Canton.
it was Canton.
Yes, sir. Yep.
You're a bulldog.
It was green and white. Still am.
So, when you were in Canton, was the only prosecutorial office that you dealt with the Norfolk County District Attorney's Office?
So we worked, I believe they're the same county, but Stoughton District Court and also Dedham District Court, depending on if there was a trial or if a jury was required. Canton doesn't have a court that directly covers that town.
So it was
Canton's Norfolk County, I'm just not positive about Stoughton and Dedham offhand.
did each court have a liaison officer?
Yes,
Who would go to the district court and be the complainant?
yes.
Did you ever go, while you were in Canton, to the district court as the complainant to file a complaint application?
No.
When you were, I want you to step back to 2017 and the time period between when you graduated from the academy and went and the arrest of the young lady.
Yes, sir.
Was there a single court liaison individual throughout that time period that you interacted with?
State police is a little different just because the area that we work covers a number of highways. So oftentimes you'll leave jurisdictions of one court and hit another. So it might not just be Worcester, I think it's the Leominster District Court, et cetera, if you're on a northern or southern portion of that patrol area. But at no point was I the assigned court officer, and I never handled the direct delivery of complaints, if that's what you're asking.
That's what I was going to
Yeah,
ask.
there was always
In
a
this
court
case-
officer with the state police
in this
because of the
case,
volume.
Thank you for anticipating, thank you. In the time when you were in Brewster, did you testify in court
Yes, sir.
often?
Not as often as now, but multiple times.
And I would like you to really focus on time period prior to the arrest of Ms. Bebo. You've been characterized in some places as a relatively new trooper. Is it fair to say that you were a relatively new trooper at the time of Ms. Bebo's arrest?
Yes.
Prior to that evening, had you testified in any matters in the Worcester District Courts?
I would have to reference court paperwork. I had made a number of arrests at that point. I don't know. From the time of an arrest to when you actually testify or have motions, et cetera, it can be months or years. As we sit here today, obviously years. So I'm not sure offhand, to be honest with you.
You don't remember?
I don't recall, no.
That's a perfectly fine answer. Were you educated by the fact that multiple packages, one for the district attorney and one for the court, were part of the complaint package that went to the district court?
Yes.
When you talk about, as you testified, that there were, well, let me step back. In this instance, you said that Trooper Ricciardi, who may have been promoted.
Yes, I believe he was a court officer at that point.
And at that point, he had not been the court liaison to Worcester for very long either, had he?
I don't know offhand.
Do you know that he was a relatively new liaison who had been there for 3 months?
He may have been. I don't know his start time in relation to this arrest.
And the court liaison individual is the complainant, correct?
Yes.
And did anybody educate you along the way, whether it was John Sheft or Jamie Majarian or anybody in the field, as to the ability of clerk magistrates to interact with the complainant and to suggest changes to the reports that they were receiving.
I'm not familiar with that process.
Are you familiar with it now?
You just told me, I believe you.
No,
I've
no,
never been present.
I'm sorry that I confused you.
No, I'm not confused, I've just never been present for it.
You indicated that the statements might be relevant to other crimes that the district attorney might be interested in, correct?
Yes, sir.
Did you bring those to the attention of the district attorney's office?
Not personally, no.
What did you know in 2017 of, let me strike that. What did you know in October of 2017 about impoundment practices?
I know for some sexual assaults it was commonplace. I'd heard or seen that previously. At that point, I can't anecdotally speak to any report that I had seen been impounded besides either domestic violence or sexual assault.
Have you ever, now I'm taking this forward, have you ever been educated in any way with respect to the items that court rule requires be kept confidential?
No, I'm not familiar.
Are you familiar with the phrase human trafficking?
Yes.
When you were considering what you should put in the report, were there specific offenses that you were thinking of?
Yes.
Did it include human trafficking?
No.
You were aware that there was a suggestion of prostitution, correct?
Yes, sir.
And you were aware that there was an individual in the car with her with whom she had been consuming drugs, correct?
Yes, sir.
And the graphic quote that you put in included the phrase "for us," did it not?
Yes.
It never occurred to you that there may be a human trafficking issue there.
No, she identified the gentleman as her boyfriend at the time.
I want you to relax, but that was a yes or no question.
No, I did not consider human trafficking when she said she had acquired the drugs.
Did you ever, and I think you've answered this, you never communicated with the district attorney's office about what else might be of interest to them?
Once this became, I don't want to say overexposed, such an issue, I removed myself from the case entirely to the best of my ability. And it was no longer appropriate for me to follow up in any manner.
And I don't object to that non-responsive answer. When did it become overexposed?
I would say the minute people took actions that they wouldn't have taken traditionally for a client with a different last name.
So let's talk about that for a minute. What difference, step back. You were concerned about the impact on your career of recent vintage though it was, because you had arrested somebody who had a last name, correct?
Well, not just a commonplace last name, but a direct relative, and then actions were immediately taken only minutes later by a bail commissioner that were not consistent with what, to me, I had ever seen previously.
You were aware, you had that concern from the moment that you heard from the dispatcher that you had arrested a judge's daughter, correct?
No, when she screamed at me roadside, my dad's a judge, then I was concerned.
Even before?
I didn't initially believe her, but it did set off some level of concern.
So at roadside, you had a concern about your future because you had heard that this young lady had a relationship with somebody. That was your concern.
I don't think at that point, because nothing had been started yet, this set of actions hadn't been triggered yet. I was aware of who she was at that point, if that was true.
So it wasn't at the roadside.
No, I wasn't concerned about my career at that moment. Nothing had triggered.
And when you were told by the dispatcher, that was not the moment either.
No, it gave some truth to her statement, obviously, but nothing had happened yet at that moment that this was going to be any different. Unfortunately, it was what it was at that point. A young lady suffering from disease that made a poor decision and crashed. Her name wasn't relevant to me. And at that point, no action, to my knowledge, had been taken that would have compromised the investigation or my career.
And so, as you told the Attorney General, this was an ordinary matter. Woman had a crash.
I'm sorry, you say the Attorney General or Bail Commissioner?
I think I said the Attorney General. And I think I'm referencing the document that you still have.
Yeah, this from me again.
Which I guess has not been offered as an exhibit. And I think in light of the testimony that we've heard today, I'm going to offer this document. I don't have multiple copies, but I'm going to offer the document as an exhibit.
Anybody have any objection to that?
I would object. The witnesses here testifying, there's no purpose to, he may impeach him with it, but it shouldn't be in evidence.
You have an objection
And
to?
it's not on his exhibit list either.
Okay, so you object to
Yes,
the
I
statement he gave to the Attorney General's
Yes.
office? Okay, anybody else want to be heard? Okay, that'll be an exhibit. I don't know who we have to give it to. Can you just hand it to her, please?
Thank you.
Thank you.
So, we're gonna hold those two numbers. Okay, so this is number 18.
Okay,
Two numbers.
Excuse me, Madam Stenographer, we just want to clarify, so Exhibit 16 is the audio of the cell phone message,
Correct.
and Exhibit 17 is what?
The letter from Colonel Gilman.
No,
No,
it's,
it's the audio of the impoundment hearing. There are a bunch of exhibits I discussed with the.
oh, so that was
before that were gonna
pre-marked?
be put- that we're putting in based on the motions in limine that you ruled on a couple days ago.
Okay,
So we have two separate recordings, we have two different flash drives, we're gonna do 16 and 17 for that, and that's why this is 18.
okay, thank you.
So I'm going to refer you, Trooper, to Exhibit 18, page 18, I think. Yeah, page 18, line 6, I believe, with my glasses. This is a very ordinary arrest. This party crashed her car, found to be impaired, subsequently arrested for these offenses. Those were your words back in December 17, weren't they?
Yes, sir.
What made this different was, to you at least, was that there were these issues with respect to the identity of the individual and what might favoritism that a bail commissioner not charged with anything might have done, correct?
Yes.
Now, we have talked about this document that is Exhibit 1. You shared that document, did you not, with the union reps with whom you were interacting in October of 2017?
With the union representative I was with at the time.
Yeah.
Yes,
That was Jeff Gilbert.
Jeff Gilbert, yes. He was in the room with us.
Yes. And was Trooper Gilbert also in the room with Sergeant Conant?
I don't recall.
Did he have a separate union rep?
I'm sorry, was Sergeant Conant in the room with myself and Jeff Gilbert with Major
There was
Anderson?
a time when you and Sergeant Conant were in the room together, correct?
Yes, I did see him that day.
And he told you on that day, don't worry, kid, it's a good report. This is no big deal.
Something to that effect.
And Lieutenant Fogarty also told you, I'm your guy. This
Again,
is
something to that effect.
I'm your, as you said, I'm your guy. This is no big deal, correct?
Yes,
Something to that effect. Whatever the exact words 5 years ago, who knows, right?
yes.
When did it become a big deal?
I think meeting with Lieutenant Fogarty, well, actually, getting summons from my house abruptly was a big deal to me. Sending a trooper to my house, my place of residence, is wildly inappropriate. That's a big deal. So that was probably chronologically the first big deal of the day, but it got big and bigger.
You thought it a big deal at that point in time.
Absolutely.
It was your concern.
Yes.
What concern did you have for the way probable cause statements should be submitted according to the colonel?
I'm sorry, sir. Say that one more time.
I can't. I have to have it. You know that.
Question, what concern did you have for the way probable cause statements should be submitted according to the colonel?
I think my concern was the avenue they were taking. It seemed very nefarious, and just the concern in the lieutenant's voice on the voicemail they left, it seemed to me as if this was not an ordinary practice. And even in my youthful inexperience, it seemed to me this is going to an avenue where I deemed it appropriate to seek counsel and union guardianship.
Well, indeed, you told us on direct that the union rep who was with you recommended that you seek counsel.
Yes,
And the counsel was Spam's counsel recommended.
yes,
And Mr. Keston is representing you here today.
yes,
And Mr. Keston has been representing you in various matters since.
yes,
Indeed, Mr. Keston accompanied you to the district attorney interview back in December.
yes.
To whom have you provided the unredacted document, whatever we're calling it, to anybody other than your union rep?
The only person I would have given it to would be my union representative or the attorney. If you're referencing the media again, no, that was not me.
I wasn't going to ask you that, but I will ask you who did.
I have no idea.
And when, with respect to the media, are you talking about any particular outlet?
No, I've never given it to any media outlet.
You would agree with me, would you not, that the content was made public within 10 days of the arrest?
I believe the other attorney had referenced that it's immediately public when it goes into public record. And I don't remember a 10-day gap, unless you're saying until it was grabbed by the media.
Well, what I know is that there was an impoundment order issued. You know that as you sit here today.
Yes,
And I know that there are procedures on impoundment. You don't necessarily know what those procedures are.
no, I'm not very familiar with the process.
But you are aware that within days of this matter, there were publications, at least on the internet.
Yes,
And it was, in your mind, virtually immediate. Correct?
think it had been a few days, but
Couple of days.
couple of days, yes, sir.
Isn't that when it became overblown? Is that the phrase that you used earlier, Trooper?
No, I think that point had long passed at that point.
May I have 1 minute?
Sure.
Okay, I have no further questions.
Okay, thank you. Yeah, Mr. Scarney, you want to say something?
I'm just very brief. I actually am going to be brief this time.
Okay, well, why don't you just save it for now, because what I'm gonna do, I just wanna go in order. You just wanna ask some follow-up questions?
It was just one follow-up question with respect to Trooper Savio just testified to.
Just one
Just
question?
one question.
Okay, I'll let you have that one question. I'm gonna hold you to it.
It's a statement followed by a question.
Okay. Okay, so that's
I'm
okay.
gonna preface it. You testified that you removed yourself from the further prosecution and involvement of the case as fast as you could. That's what you testified to, right?
To the best of my ability, I'm still a witness at the time. If they had gone to trial, it would have been necessary for me to be present.
That was my follow-up. I was gonna say, if she exercised the right to trial, you would have been, you'd be involved in the case, right?
If I was subpoenaed unless my counsel advised me otherwise, yes.
Great. That's all I had to ask.
Okay, thank you. At this point, I'm going to ask Mr. Bourgeois whether you have any questions of this witness.
What I'd like to do, sir, if I can, it would get me down to one question or none, is read into the record an agreed upon stipulation that touches on some of the testimony of the trooper, if I may.
Okay,
May I ask which agreed upon stipulation he's referencing?
I have a feeling he's gonna sit in a moment, okay? I have.
Just wanted to be able to get.
No, I know, I understand.
And it is Travers stipulation number 1, which is agreed to by all parties as established in this case. It is as follows. Jeffrey Travers was not a party to any of the civil lawsuits that arose from the Bebo arrest. And with that, I would only have literally one question.
Oh, go ahead.
Trooper Trevor, my name is.
Yes, sir, I'm good, thank you.
I represent First Assistant District Attorney Jeffrey Travers. My question is this. Is it fair to say during the entire course of events that began with the arrest of Ms. Bebo and ended with your testimony today, you've had no involvement, interaction, or communication with Jeffrey Travers?
To the best of my knowledge, I've never met Jeffrey Travers. I had no interaction with him whatsoever.
Thank you, sir. That's all, Your Honor.
Okay, thank you. Once again, I want to see if we can possibly finish today for obvious reasons already alluded to. Do you have any questions? I don't want to limit you.
We want to take just a 2-minute break,
Maybe a little more than 2 minutes, maybe 10.
and I think that we can finish up the redirect fairly quickly.
Well, I don't want to bring your feet to the fire, so when you say fairly quickly, about how long do you? Because it is 1 o'clock. I know some people might be hungry. Frankly, I would like to keep going through because to get people out of here.
Agreed, and that would be my intention.
Okay, so a 10-minute break. Does anybody have any objection to taking a 10-minute break, coming back, and then we'll get out of here early?
Thank you.
No, thank you. Okay, thank you.
But we don't have Mr. Bourgeois back, I don't know if he's.
I think he
Oh,
came.
there he is.
Yeah, I saw him come. He
Great.
ducked in, he ducked
It's like
out.
magic.
So okay. Okay, so Ms. Morang, you want to
Thank you, Your
on
Honor.
your redirect?
Yes.
Thank you.
Trooper Sevior, on cross-examination, Attorney Burke asked you whether paragraphs 8 and 9 were done after Judge Bebo and his daughter left the barracks. Do you remember being asked that?
Yes,
Was the whole report done after Judge Bebo and his daughter left?
yes, the report in its entirety was composed post-bail process.
Thank you. And I'd ask you to look at Exhibit 1, paragraph 9.
Thank you.
Paragraph 9, line 3, referring to sexual acts for drugs. Do you see that?
Yes, ma'am.
Was this statement in paragraph 9 related to your conversation with the bail commissioner?
No,
And then one last thing, you said that after you were interviewed by the Attorney General's office that you underwent some training for OUI, is that correct?
yes,
And was a portion of that training about report writing?
yes.
Were actual reports used in that training?
They made reference to this report.
Was there any report used in that training that you recognized?
The references were to the report that I had written.
And when the references were to the report, is that as to Exhibit 1, that report,
Yes,
containing the statements that we've been discussing?
yes, they made reference to them.
And when they made reference to stipulated Exhibit 1, what were the references?
That it was appropriate to include quotes and lines that would reference impairment.
Thank you, nothing further, Your Honor.
Thank you very much. Mr. Burke, do you have anything on recross based upon what the redirect elicited?
So can you tell me how the line, you have no idea how many dicks I sucked to get for this, it reflects impairment?
I think someone with a clear head and clear mind wouldn't speak like that to a state trooper. I think it's indicative of somebody with a compromised sense of reasonableness.
So that's the basis. Did you say this is the reason I put this in here? In my opinion, it's a compromised intellect?
That's a portion of it, but I think it also helps identify probable cause.
This was a gratuitous statement made because you believe the bail commissioner had given her and her father preferential treatment by returning that $240. Isn't that true?
Absolutely not.
Thank you.
Okay, thank you. Ms. Rusconi.
Just briefly, you referenced, Trooper, you referenced somebody, those statements would represent somebody who's, I'm paraphrasing, that mind was compromised or intellect was compromised. You hadn't met this person prior to this, right?
No, sir.
You have no idea what a personality is like.
No, sir.
You agree everybody's different?
Yes, sir.
Some people are forthcoming talking about certain things while others may not be.
Yes, sir.
All right, and you would agree that in situations like that, it doesn't necessarily mean the person's intoxicated or not.
No, sir.
Thank you.
Okay, Ms. Conley.
Can you place the training that you underwent in time relative to the exhibit that you were shown being a letter to you that you characterize as an apology letter from Colonel Gilpin?
No, sir.
Can't place it whether it was before or after.
I can't, no.
No further questions.
Okay, thank you. Mrs. Bourgeois, do you have anything? Nothing. Ms. Bourgeois. Okay, well, I think that wraps it up with this witness, sir. Thank you very much.
Thank you, sir.
I appreciate
Appreciate
your
it.
presence. Thank
Absolutely.
you, and I thank you, your attorney. Thank you. Thank you, sir.
Good holiday.
Thank you.
Everyone,
That it?
whichever holiday
Thank
is
you, that's
celebrated.
Awesome.
Thank
Thank you
you.
very much, everybody.
Thank
you.
Take care.
Thank you.
So, the petitioner indicated they want to introduce certain exhibits. How long will that take, and can we delay it until Wednesday perhaps? But I'll see. What do you want to do?
Oh, we could do it on Wednesday, I mean,
Weren't we
We have
gonna
two
try and talk about
witnesses.
it? Weren't we gonna try and talk about that? I'm sorry, Judge.
Well, why don't we do it just Wednesday, okay? Just,
yeah, well, can we get one in right now, because we thought it was in a visit, so.
okay,
Why don't we take care of one, and then the rest of them we'll take care
okay,
of.
so we'll
It
deal.
next week.
is disputed exhibit number 14. If we could have that marked, it's the Colonel Gilpin letter, if we could have that marked as the next exhibit.
Which would be number 19.
I have a copy.
Is that what you're referring to?
Yes, that's it,
Okay.
exactly. Do you want me to use this one? Doesn't matter? Okay, then I'll.
I thought you wanted to.
I have no objection.
Okay, I take it no one has an objection to that. thank you. Okay, so is that it for now?
It is.
I'll apologize I'll apologize in advance because it's now Friday, we're not meeting again until Wednesday. And we talked about 2 additional exhibits, that would be out of sequence, so 16 and 17. So 16 is, the recording of, Trooper Sevier's voicemail with Lieutenant Fogarty, that's 16 and it's on a flash drive.
Sure.
And 17 is the recording of the impoundment hearing, also on a flash drive. So if I could give those to the court reporter and then we'll do the rest next week.
Are you gonna play that at some point, exhibit 17?
Hadn't intended to.
Okay, well, something to, okay, thank you. Is there any objections to this? I take it not.
I'm gonna guess.
Your Honor,
Yes.
if you'll recall, there was an objection that was resolved when you ruled that transcript, that recording went in with the Roberta O'Brien statement. So I want to make sure they both go in together.
Counsel, have you provided the Roberta O'Brien, I'm sorry, Commissioner. I think if he wants to get Roberta O'Brien's statement in, then he needs to.
I think I
provide it.
indicated it would go in, so it is going in. Is it in already? Okay, it's not in yet, so we just have to.
Well, one of the things you could do, if I could suggest, is I think the recording is exhibit 17. Why don't we call Roberta O'Brien 17A or 17B?
Okay, does anybody have any objection to that?
I can't object, but I don't see the need to deal with it today if he's got this O'Brien thing that he wants to put in.
Well, I'll do one of 2 things. I'll delay this until Wednesday, so you have an opportunity to talk to Mr. Bourgeois.
Yes, but I'm gonna defer to Mr. Bourgeois.
Okay, so that would be, O'Brien letter would be exhibit 17A, okay? Now,
Thank
do
you,
we have that O'Brien letter?
Affidavit.
The affidavit, do we have that?
We'll provide, I don't have it here today.
So we'll provide it on Wednesday.
It was attached to my partial opposition, and my memory was I handed it to you on the first day during the discussion. I'll get another copy.
Yeah.
I'll get another copy to Ms. Duca.
Okay, and you don't have to do it now. You can just do it on Wednesday, and you're correct, it was attached. I remember seeing it.
I will be able to do it when we go back to the office. We can pull, I think.
Okay.
Yeah, what do you mean we?
We can do it.
Well, yes, I think she's gonna do it. Okay, well, if there's nothing else, have a safe holiday, long holiday, happy Passover, happy Easter. Be well and healthy.
Thank you, Judge.
Take care. Thank you.